How about now? Can you hear me at all?
Yes, sir. We can hear you now.
Is it staticky?
No, sir. It's great.
Okay. Just a little off and on trick. Sorry about that. Thanks for letting me know. It's possible this is a new board, but it's a known issue with this new board. And the only fix is this. So works great when it's working. And it's usually working. If you haven't already, and most of you looks like have, put your name in the chat for me. And then make sure that you have that little blue box set to everyone so everybody sees whatever it is you're putting in the chat, unless you want to send me something, a question or something privately. Okay. By the way, we do have your study schedule available there in the student Google Drive. We're in good shape. Tonight we're going to cover, even though we're here on November 10th, we're going to pretty much get 3, 4, 5, and 6 knocked out. We fit a lot of license law into that first week on purpose, so that throws us off on our dates here a little bit, but we're in great shape because we still have lots of time at the end to work with. And I'd rather you start focusing on that license law and commission rule as we discussed earlier. Now, let's do a little bit of a review from last night. We talked about there we go. Talked about all kinds of stuff. That's just a dense chapter. Chapter 2, we talked about fixtures. We talked about how estates of ownership and then multiple partner ownership. So all kinds of input going into your brains last night. And it's going to be about, I think we saw on the breakdown, 4 questions on the national could come from this chapter 2, unit 2, and 1 from the state. So it's just a dense chapter, and you just never know which one's going to be on there. So you do need to cover it. When it comes time for review, you'll probably spend more time on chapters 7, 8, 9, 10, 14, and 15, and 17, and 21. Those are all sort of the meat in the sandwich. They're the biggest chapters in the whole course. Not that they are any more important, just that there's more of a chance of questions coming from those than these other ones. So in real life, you need to have a firm grasp on this concept of fixtures as well. So keep that in mind, and it's just a little different out there in the wild. We learned about IRMA, the total circumstances test called IRMA. But in real life, in the business, there's a bullet point list that specifically says these are what we are considering fixtures. For your test, remember IRMA. Let me find where I am. Okay, there we go. And that is the intention, the relationship, the method of annexation, and the adaptation to the real estate. We learned that was the original intention for it to be a fixture. That's going to be the thing the judge in court, if there is a lawsuit, that's going to be what the judge really focuses on the most. Did this owner, seller intend for this to be a fixture back when they put it in? They may have changed their mind when they had it on the market, when they got under contract, and then they got angry maybe at the buyer for asking for, maybe the buyer lowballed them on the price. Maybe the buyer asked for more things to be repaired than the seller thought they should. It's very emotional. This business is sort of about surfing the emotions of your client. And I think the big mistake that agents make is getting in the emotional dirt with their client, not rising above it, not buffering it out. It's so tempting for sometimes for agents to try to maybe score some points, get build some rapport with their client by just kind of getting down in there and saying things like, yeah, that's, how dare they, I can't believe they would do that. But that seems to work against the whole overarching point. The point is to get everybody to closing, right? Satisfy your client's needs, get to the closing table. So by fueling the fire, in those emotional moments, you're kind of making it worse. And there's nothing worse than being on the other side of a transaction from an agent that operates that way. So it's good for us to kind of rise above that. So in a dispute, the judge is going to say, what was the intention? They're also going to say, what was the relationship of the person who attached this thing? Is this a tenant who screwed something into the wall? Then that tenant might have had every expectation of taking it with them when they moved out. Or was it an owner? And in that case, the owner may very well have intended for that to remain before they even thought about selling. How is it attached? Is it going to be something that's going to cause damage when you remove it? Is it highly customized? And then has it been tailored along with the property to work together with the property? So don't forget about the fixtures. What the test could do to you, the test question could be written in a way that they talk about a very expensive, very elaborate, large, heavy item. But don't let that throw you, because none of that matters. None of that dictates whether something is a fixture. IRMA dictates the fixture status. The size, the value, the location, all irrelevant, has nothing to do with whether it's a fixture. And it goes the other way too. Something really tiny and inexpensive could be a fixture as well. Even a light bulb. A light bulb is a fixture, right? The overarching lesson we have here is put it in the contract. Write it up. Never assume. Make sure that it is documented so everybody can remember in those heated moments, oh yeah, we did put it in writing that the chandelier in the dining room is going to go away. It will not convey with the house. It will not stay with the house. A couple of exceptions to the fixture rule. Something called trade fixtures are actually personal property. Catching up in the chat here. Yes, Danielle, we're going to pick up where we left off last night with the hybrid ownership types. I think we left off with townhouses. And then, yeah, if the seller wants to take a fixture, then the proper procedure is to write it up in the contract. First of all, if they know up front, they would let the whole world know. Just disclose it. Put it in the multiple listing service, right? And say, look, by the way, you might fall in love with that chandelier or those window treatments and those curtain rods. They don't stay with the house. Between you and me, as a business practice, not a great idea. The best practice is to actually get rid of them, take them down before it goes on the market. Don't even tempt the buyer with them, because usually the buyer wants what they can't have. And if you're showing it just because it looks pretty, and it's going to make for better photos to have those things in, but those things aren't staying with the house, it's possibly going to work against you. That buyer might feel a little differently about the house once they find that out. They will almost always ask for it. Yeah, that's the proper thing to do, Gregor, is to replace the chandelier with something else. It probably won't be as expensive, as nice as the one that you want to keep, most likely, but that's okay. They never knew what was there to begin with anyway. As long as there's something there, that's the key. And that's probably the best practice. Than to just sort of dangle a carrot in front of them that they can't have because your seller's taking it with them. Trade fixtures are not real property. They're the type of fixture that's not real property. They are personal property because the tenant needs them for their business. And we have a hair salon here, so those sinks are screwed down, plumbed in, they're attached. So they're officially fixtures, except for the fact that it's a commercial space that's being rented by a hair salon. And that owner brought them with them, and they're going to take them with them when they go. It's a trade fixture. It's a piece of personal property. Agricultural fixtures, now we're back to real property again. It's a tenant who's renting this farm and using it and growing their crops. But these are considered real property, not personal. The tenant cannot remove these at the end of their commercial lease. Uniform Commercial Code, if you finance your fixtures, then they are not real property until they are paid for. That can be interesting too when it's time for under contract. We talked about the difference between a mobile home, manufactured home, and a modular home. What does it take to turn a manufactured home from personal property into real property. Yep, that's one of them. Remove the wheels and the hitch and the axle. Step 2, put it on a foundation. You got it. And then step 3. Yep. Fill out that affidavit with these guys, the DMV, Department of Motor Vehicles. Let them know, look, this thing can't move anymore. It's real property now. Please make it be so. Here's the paperwork. That's different from a modular home. Modular home, just like the mobile or manufactured, they're both built off-site somewhere else in a factory somewhere, but the modular comes in big pieces. The manufactured does too, but it has its own wheels. The modular came on the back of a truck. And the moment at which it becomes real property is when it is assembled on the site, on the foundation. You have to get a structural engineer to write a letter to the state every time. Which one? Every time it's sold or leased. You're talking about mobile or modular? No, it's going to have paperwork in place that will acknowledge that it is real property, and it's attached. It's assembled on site, so that would be verified by the inspector when they do their thing anyway. So that's not something you need to do every time. Then we got to this guy, the subject of estates, and this chart I find pretty helpful. Non-inheritable. What does that mean? What do you mean by non-inheritable?
You can't pass it down.
Yeah, there you go. Thank you. You can't leave it to your heirs. You can't pass it down. You got it. And there's two types. The conventional life estate. Tell me about the conventional life estate. Somebody unmute and tell me a little bit about that.
It depends on your life. So once you die, you don't own it anymore, and you can't pass it to anyone else.
Perfect. Do you remember the terms? What's the person called who owns it, who bought it, that has that life estate? What's the term for the person? Some kind of a tenant.
Life tenant?
Yeah, there you go, the life tenant. And then the person on whose life the duration of ownership depends is called the, what kind of life? The measuring life. And in a conventional life estate, that's the same person. That's exactly right. What are two more terms associated with the life estate that have to do with what's going to happen to it once the measuring life dies?
Reverse?
Yeah, the remainderment and also reversionary. It's going to either revert back to the one that sold it to them, or it's going to go to a third party called a remainder. And that could be a charity, it could be an entity, as well as a person. That's the gist of it. And the big difference between a conventional life estate and the inheritable life estate called an estate for the life of another, this estate pour vie, is that the life tenant and the measuring life are not the same person. That measuring life is a different person altogether, which opens up the possibility that the life tenant could die before the measuring life dies. And in that case, it's still a life estate that's in place. And it's going to pass to the heirs of that life tenant. But hopefully those heirs understand that they're not getting something forever and ever. They're not getting a fee simple absolute type of ownership. They're getting a life estate only for the duration of that measuring life. And maybe they'll buy a gym membership for that measuring life. Maybe they'll drive them carefully back and forth to work and help them eat properly. Maybe they'll help them extend their lifespan, right, so that they can own this thing as long as possible. A lot of times the life estate will be utilized when maybe there's a little old lady, little old grandma, grandpa who still wants to live. They want them to be able to live in the place they've been forever and for as long as they live. For just the duration, or however much longer it is that they're going to be alive, let's upset them, move them up, move them out. Let them live there, and when they die, then the ownership will transfer. Sometimes it's handled for that type of purpose. The marital life estate was a type of non-inheritable, and that has to do with what? We're talking about marital life estate.
Married?
It's about spouses, it's about married people, and it has to do with if the spouse who dies tries to cut the living spouse out of their will, or leave them. Yeah, there's a bare minimum that surviving spouse is going to be entitled to because of the marital life estate. And you could actually Google the chart. You don't need to know the chart, so I don't want to confuse you with it, but it will show you how many years the person's been married is in line with a certain percentage of ownership that they are entitled to of the remaining estate. That's the gist of the marital life estate. That leaves us with two more, but they're over in the inheritable group. The best one is what? Out of this whole slide, what's the best way you could own something?
Be simple, absolutely.
Absolutely, that's it. The one with the least restrictions, fee simple, absolute. Now these restrictions. It doesn't have restrictions put upon it by the seller, but it could still have restrictions depending on where it is. Because there are other ways we have restrictions that are applying to property. One of them is zoning, laws. Right. Another one could be private deed restrictions. This is one thing. This type of estate is one type of restriction, but it could also be that the property has private deed restriction placed upon it, which says that you can only build a certain type or style of house, or you can only put one house per acre. You can never put like 5 houses per acre, not a high density kind of development. That might make you more money, but if you buy the property with that private deed restriction in place, sorry, not available. You're going to have to follow the deed restriction. A lot of private deed restrictions have to do with neighborhood rules. And when you live in a neighborhood with an HOA, the HOA is going to have its homeowners association. That's what HOA. There's going to be HOA rules about things like size of the fence, height of the fence, color of the door and the shutters. Maybe even strict rules like that garbage can be at the curb no more than 24 hours of the day. And if you leave it there longer than that, you get a notice, a letter, maybe even a fine. So there's HOA rules, but there's also potentially private deed restriction rules too. What if there is no homeowners association, but the neighborhood does have covenants, conditions, and restrictions? Those are also called CC&Rs. Have you ever heard the term CC&R? It stands for covenants, condition, restrictions. You can have a neighborhood with CC&Rs, but no HOA at all. And so if the HOA, homeowners association, is who is going to enforce the rules, but they're not there, how do you enforce CCRs, no HOA? The neighbors. Your lovely neighbors will tell on and sue you over the thing that you're breaking the rules if they want to go through that. So that's the way that with an HOA would send you a letter that to a letter they would find because you moved in there, you've been there, you live in the HOA, and so part of that agreement is following. By the way, if you don't pay your HOA dues, what's the most severe extreme thing that can happen if you don't pay your HOA dues? What's the worst that could happen? Foreclosure. The HOA is powerful, guys. If you don't pay them, those dues, you got to carry. You got to put a lien on it towards foreclosure of the house. It's a big deal. That's why people are so used to HOAs. They either like them or they don't. And some areas have worse HOAs than others. Right. Sometimes. What's a positive about a homeowners association? Since we're talking about it, will be a good thing.
It makes people mow their yard.
There you go. And you know, in the yard, keeping the car doesn't run, doesn't have wheels from being propped up on cinder blocks in the front yard, that sort of thing. Why is that important to the neighbors to have such rules in place?
It helps keep their house value up.
That's it.
Look better as well.
You got it. Keeps those values. That's the idea. Some people say, well, to an extreme. You don't need to have rules quite that gist of it, the gist of it, of an HOA, having rules in place people from doing something that will harm the valuation. So just about the time you want to put your house on the market and sell it, your neighbor across the street has a bunch of stuff wrong, they paint their fence pink, they paint their front door purple, like a loud neon, they have a junk car in the front, they don't take the trash, they don't mow the grass. Not a great time for right? You're probably going to have a hard time selling your property. And that's the point. It's when there's an oversight. It's when there's somebody on the HOA board who's in charge of finding the violations, sending the letters, that gets a little carried away and starts to kind of exercise their power a little too much. That's when people get frustrated with them. But even if there is no HOA, you can still have covenants and conditions. But here, what we're talking about with these freehold estates are another kind of condition placed upon the owner, the seller that they bought it from. And so fee simple absolute, the last way, the last one, which I think most people struggle with most, that's the middle one. Fee simple, defeasible. And I think part of the problem with this one is the naming. So the feasible, determinable type of ownership means what? What's the restriction there?
You must keep using it.
You have to keep on using it the way that you're supposed to use it. That is it. And then the other one, subject to a condition subsequent. What's the rule about what's the condition?
You can't do something with it.
You guys are good. You can't use it in a certain way. And the example might be no alcohol. The other one might be you must always use it as a farm. Something like that. The other thing about these is what happens if you do it wrong. If the condition is violated in a fee simple determinable, because it is runoff. Sometimes people will shorten it, but it's officially all of those names together. Try hard not to let the words that start with the same letter throw. And again, when you say defeasible, I like to think defeat because it can be defeated. But simple, defeasible, there are two types of that's the one up here, and there's two types that branch off. Determinable, which means you have to keep using it in a certain way. If you violate that condition, then it automatically reverts back to the seller. The other one that says you can't use it in a certain way does not automatically revert back to the seller. The seller would have to pursue the buyer. You'd have to sue them to get it back because they violated the rule. Okay. Let's go to Then we talked about how many people can own something, and what happens when multiple people own things.
You have to be put in the deed.
What is it called when one person owns property?
Zero.
Yeah, there you go. Ownership in severalty. One second. Let me get the right one going here. There we go. Ownership in severalty means one person owns it. Just focus on the word sever, meaning one piece. So one owner. When somebody buys something all by themselves, they're in severalty, but then they get married a year later. How is the property owned by those spouses?
And in front.
Yeah. It's not automatically by the entirety, is it? It doesn't automatically switch. They could. If they want to. They would have to go through that. And they'd have to go to an attorney. Say, hey, I bought it by myself. Now I'm married. You want to change it to tenants by the entirety. Please do that. The attorney's going to rewrite the deed and write it with that language. Tenants by the entirety. And they're going to pay them a couple $100, and there you go. Done. What's the attraction of tenants by the entirety? Why do we like that? Why would married people like it?
We have right of survival.
That's a big one. That's the big one. Probably the biggest. And what does that mean?
That if one dies, the other one
Gets all of it. That's right. It doesn't go to the heirs. It goes to the surviving owner. Hopefully the surviving owner still likes the kids and will let them keep living there. But it doesn't go to the heirs automatically. That right of survivorship built in by the tenants by the entirety. There's that cursor. So if single person buys the property, then they marry, they are tenants in common. They'd have to get an attorney to set it up. Here's some things that apply to tenants by the entirety. If you want to own it as tenants by the entirety, and you buy it once you're married, the attorney is probably going to go ahead and write it up that way, unless you tell them otherwise, because it's so prevalent. By far, the most typical way to own something when you're married is this way, and also the most common way to own something if you're not married is tenants in common. We don't do joint tenancy that much. Let's look at the rest of this little list here of tenants by the entirety. It has right of survivorship. Both sides sign in order to sell it. You can't sell it out from under your spouse. Both have to be aware of it and sign off. There is no right of partition option. You can't sue your spouse in order to force them to sell it so that you can cash out and get your part of the money. And it's by far the most favored ownership for married people. The way it could go away. Death, legal agreement, and divorce. You start out maybe you buy it as you're married people, the attorney writes it up as tenants by the entirety. But maybe one of you is an investor, the other one of you is not. You're not really into that, and you decide, you know what, we're gonna upgrade. We're gonna move to a different house. We don't want this one to be tenants by the entirety anymore. Let's make it tenants in common. And so you just have an attorney draw and stop it from being by the entirety, and they change it over to tenants in common. Married people can own it any of the three ways: joint tenancy, in common, or by the entirety. But they tend to own it this way. And then as brokers, we need to make sure that we understand if the owners are married or not. It might be awkward asking such questions for you in the beginning. Sometimes it's like a personal question, but you need to know this. It matters to their best interest. So you have to ask this stuff. Are you really divorced, or are you just separated for a long time? Got to make sure that they are divorced, so that you know who needs to sign the listing agreement with you, so that you can put the house on the market. By the way, you can't list the house without all of the owner's signatures. Not an option. You only have one of the two signatures you need. You don't have a listing, and you can't put it on the market yet. Then we talked about tenants in common. It's the most common. It can be unequal compared to joint tenancy. Tenancy in common can be unequal ownership interest. Let's look at the little breakdown here. There it is. Unequal shares versus equal shares. You can buy at different times compared to joint, which means you have to buy at the same time. And then there's no right of survivorship. If you want to have it so that your part of ownership passes to your heirs, then you would need to choose tenants in common. So beware of that test question, which could say A, B, and C own something as joint tenants. C wants to leave it to her heirs, and C dies. What happens to the property? It's so tempting to say, oh, she wants to leave it to her heirs, so why can't she? So she just does. It goes to her heirs. No, she owned it as a joint tenant. And part of joint tenant ownership is it can't go to the heirs. It has right of survivorship. It goes to the others. Now, instead of a property being owned by 3 people, there's a property owned by 2 people. The 2 surviving owners. With me? Good faces. Okay, good. All right. Let's come on up to speed. We talked about condos. That's airspace. When you own a condo, what do you you own the airspace, but how do you own the common area when you own a condominium?
All the owners.
All the owners own the common area as what? Tenants. Tenants in common. There it is. Yep. Tenants in common own the common area in a condominium. That's different from townhouses. Let's look at townhouses. Compared to a condominium. With a townhouse, you own the dirt also. There's not much of it, but you own the land that it's sitting on. Not in a condo, but a townhouse. Sometimes townhouses are built, or I should say condos are built to look like townhouses, but the official legal classification is it's a condo. So it could look like this, but you don't own the dirt. So you got to be careful. Just because it looks like one thing doesn't mean it is that thing. You need to look at paperwork and find out from them, how is this structured? How is this set up? Is this thing a condo or is it a townhouse? Because that matters in terms of who owns the common area. Let's look at the rest of the townhouse, the townhouse. Think of condos as horizontal ownership. Yeah, it's not a painted surface to painted surface thing. It's the structure, including the outside. Although you probably are going to have the HOA who replaces the roof for you. But you do have more responsibility about the structure itself. It's the structure and the land, whereas the condo was just the airspace, basically. Yeah. So think of townhouses as vertical ownership and condos as horizontal ownership, right? Wall to wall, compared to townhouses, up and down, land all the way up. When we're talking about the common areas or the common elements in a townhouse community, that's another difference between that and a condo, because the HOA is the one who owns the common area when it's a townhouse community. Not the unit owners, but the HOA. And so you pay money to the HOA and you have the right to use the common area. So that's the big difference on the test. Who owns the common area in a townhouse community? The HOA does. Who owns the common area in a condominium complex? The owners do as tenants in common. You can write that one down. That's a pretty testable question. Now, another kind of hybrid ownership is this thing, and we don't see this too much. You ever heard of a co-op or a cooperative ownership structure? They're more in big cities. New York has co-ops. I only know this because of TV and movies. I think there might be one cooperative in Charlotte, far as I know, that I've ever heard of. And we just don't do it very much. A co-op is not at all the same as a condo or a townhouse. It possibly looks more like a condo, by the way, like a horizontal look. However, your ownership is different. You own a share of stock in the corporation that owns the building. And so that stock certificate is in place of getting a deed. On a condo and a townhouse and a single family normal freestanding house, you have a deed that represents your ownership, sort of like the title to your car. But with a co-op, you don't have a deed. You have a stock certificate in the corporation. So it's that gives you your ownership. But then the thing that gives you the right to occupy your specific unit is a proprietary lease. So it's sort of a 2-document arrangement here for a co-op: a stock certificate for the deed in place of the deed, and a proprietary lease that lets you live where it is, in whichever unit that you're in. So you have 2 documents with a co-op, and that's it. That's about all you need to know about a co-op. And then finally, the timeshare type of hybrid ownership is not a deed at all. It's an amount of time. Anybody ever sat through a timeshare sales pitch? Hands up. Yeah. Was it fun? Were you happy with the thing you got for free in exchange for sitting in there for 5 hours? Maybe, maybe not. Maybe that gift certificate was worth it. Maybe the free stay was okay, but they just kept bothering you, didn't they? Right? So a timeshare is a right to occupy it for an amount of time. You don't get a deed, you get the right to be there for an amount of time. And here's the numerical, I guess we could call it sort of a numerical acronym. The way to remember this with the numbers, 55510-5. You get to live there 5 times over the course of 5 years or 5 periods. The third 5 means that you have 5 days to back out of it, a right of rescission. Where's another case where we heard of something like this, like a right of rescission, some time that you might have to back out of your purchase or have buyer's remorse?
Is it a condo or apartment?
Yeah, it was a brand new condo.
Brand new.
You got it. Yep. Because of the Condominium Act of 1986 in North Carolina, you buy a new condo, you have a 7-day right of rescission in that case. With a timeshare, you have 5 days right of rescission to back out if you need to. And then the developer has to hold your deposit. Your earnest money deposit, the developer is required to hold it for 10 days. By the way, where's the developer going to hold it? How would they go about holding your money? In what? You got it. There's that word again. We learned a little bit about trust accounts the other day. The developer has to have a trust account. They're going to put your money in that trust account and hold it there for 10 days. And then the last 5 is something we've also already covered. And this is the amount that the developer is going to be fined if they violate the Timeshare Act. The Timeshare Act dictates how they're supposed to handle the timeshare. Sort of like that Condo Act. You got to have certain documentation in place. Well, if they violate provisions of the Timeshare Act, they are fined $500 per violation. So a timeshare might have hundreds of units. That could add up pretty quick, right? That's the one case. Who fines them? Who's fining them this $500?
The commission?
You got it. The Real Estate Commission. This is the one case where they fine a licensee, because if you're going to be a timeshare developer or a salesperson, by the way, you have to have a real estate license. Timeshare salespeople have to have a real estate license also. That's something to jot down. And there it is. Timeshares are regulated by the Real Estate Commission. They are given a certificate of registration. Certificate of registration. They got to register their timeshare project with the Real Estate Commission. And the salespeople must have real estate licenses. I don't know that that's the case for every other state. I have a suspicion that the other states that you might have sat through a sales pitch in, maybe Florida, maybe Nevada, I wonder if their salespeople have to have a license, and maybe ours behave a little better because they are subject to the Real Estate Commission discipline. That's just a guess. Okay, pop quiz. Owner has the title to the unit and owns the common area with other owners. What are we calling that?
Condo.
That's a condominium complex. You got it. Title to the unit, meaning the deed. What about the owner with a title to the unit and they also own the land and the building?
Townhouse.
It's a townhouse. You got it. And then what's the thing called where the owner has a share of stock in a corporation and a proprietary lease to live in their unit?
Cooperative.
That's the co-op. You got that right. And what we just covered, ownership or leasehold for a certain period of time is a timeshare. We can own real estate in a trust. It can be held in a trust, a legal trust. In this event, you've got a grantor, the one who's leaving the property or giving it or putting it in the trust. You've got a beneficiary, the one that's getting it. But then you have a third person. This third person in a trust is called a trustee. They're the one who is in charge of it. And it may be that mom and dad are given an apartment or condo or something to their kid. But the kid is 18. And until the kid is 30, the trustee is in charge. Or it could be a chunk of money that is also in that trust. The kid has access to that money, but they have to ask the trustee. They can't just spend it on anything. They have to run it by the trustee. Maybe because the parents passed away and they set it all up that way so that the younger age kid could have access to things but not burn through it and behave irresponsibly. So that third person is a trustee holding the assets for the beneficiary. The one who's giving it to the beneficiary specifies how those assets are going to pass to them. Do they have access to any of it? Or is it just going to sit there until they turn a certain age? Maybe they don't have any access. They just know it's coming. They turn 18, but sorry, you're not getting what's in that trust until you're 30. There's several kinds of trust. Living trust is something you put in place during your lifetime. Testamentary trust is about your will. You could, if you put your estate in a trust, you could possibly circumvent the probate process. When someone dies, their executor of their estate has to go tell the government, tell the county and the city that this person died and open up their estate, open up probate, which means we need to put all the affairs in order, make sure that the deceased doesn't owe anyone money. Got to put a public notice out in the newspaper for a certain number of days to give those creditors or potential creditors a chance to come and let us know that the one who died owes the money, and then pay them that money out of the estate as part of the probate process. Trust can help streamline giving people this stuff without having to go through probate. So there are effective tools that people who have some financial intelligence tend to use. Another kind of trust is a land trust. That's something only for real estate. And then there's a way that you can own real estate without having to lift a hammer and do any sort of renovation. You can be a real estate investor without having to ever go into the real estate itself. And that is called a real estate investment trust. Anybody heard of an REIT? It's basically a whole bunch of real estate all lumped in together, sort of like mutual fund. You're buying a share in this real estate investment trust. So that's another kind of trust. You can own real estate. You're not ever going to visit that real estate, but it's throwing off some cash flow of dividends, and you're going to benefit from that hopefully by investing in real estate in this way. You're investing in REIT. You don't have to go find a super great deal. You don't have to go to the mold infested house and fix it or flip it or rent it. None of that. You just buy shares in this real estate investment trust. The terminology you know about trust is the one who gives it is the grantor, or the trustor. Either one. You'll notice. I'll show you a slide later on. Anytime it's the person giving, whether it's a contractor, or in this case a trust, the giver of the thing, the word ends in OR. And the receiver of the thing, the word for them ends to ease. So you could think giver, or receiver, right to ease. And here it is, trustor and trustee. The trustee is the one who is controlling the property, because the grantor told them, here's how I want you to do this. The beneficiary is the one who's going to end up getting the assets that are located in that trust. Now, when you die, we talked about probate. Let's dig into that a little bit. It's the legal process of distributing the assets. When somebody reads a will, it's because it's part of that process. And there's going to be the person in charge of the deceased person's estate. That person's going to either be called an executor or possibly an executrix. Back when we don't hear about the word executrix much anymore. It's officially sort of a male and male. I think they're always called an executor now. So the executor is the one carries out the wishes, and it's not fun. It's not fun. I guess it's an honor. But it's a lot of work. You have to go down to the courthouse. You have to wait in line, fill out papers, copies of the death certificate. Reach out to the insurance companies, and maybe if there's a car loan, and the mortgage, and more credit cards, and all the banks that they might have statements in, accounts in. It's work. It's effort. You got to put that papers in the paper. That public notice, any creditors may still be owed. But a way to probate on that last hole in real estate, and potentially avoid having the real estate through the probate process upon death of the owner. Couple more terms to know or to alert here. Pertinent. And I've already learned that. It's a benefit. It's running with the benefit to the land. And a pertinence is a benefit with the land. An encumbrance is the opposite. It's a burden. Anybody have a guess as to what might be something that could be an encumbrance? Yeah, interesting. You did real estate investment trusts. Bear Stearns, you're saying? Yeah, it's good stuff. It's a good way to do it. What's an encumbrance? If you were to maybe have a picture of one, right in front of your eye, would your guess be as to what an example of an encumbrance might be?
A fence.
Oh, you're a genius. It's like you read my mind. It's almost like the maker of these slides was intentional or something. And you can't really tell as pertinent. That photo is a straight driveway. It's like a driveway. Perhaps a driveway across your neighbor's land. It's a benefit to your land if it's across there because it's getting you access to the roadway right of way. The encumbrance is some sort of might be the fence is across the property line. Now we have a problem. If your fence is over your property line onto your neighbor, you want to sell your property. When the survey comes out, they're going to make a note of it, or it could cloud your title. It could be a problem. It needs to be addressed because not within your own boundary lines. And if your buyer for your house is getting a loan, the lender's not going to be thrilled. Find out that your fence, the property that your potential borrower they're going to loan money to isn't in the boundaries of the property. It needs to be handled. It either needs to be moved, which could be pretty expensive, or you could maybe sell a little sliver of land so that you now own all the land the fence is on, or you could maybe get something in writing, some sort of an agreement between the parties. Okay, I'm fine with this. I know it's on my land, but I'm okay with that. I'll put it in writing. There's positives and negatives for all those different methods. It comes back around if you're the broker in a transaction where there's an encumbrance like that. Comes back to time. How much time will it take to get this resolved, and can we still close when we want to? This is going to take a month to get it fixed and figured out. Oops, now we have a problem, right? So appurtenances and encumbrances, we're going to get more into these encumbrances. A fence would be probably one of the easier. It could still be expensive. I sold a house in historic neighborhood up in Mooresville, and to look at the fence, you would never expect it was over the property line because it was perfectly straight. It was a perfect rectangle. The house was situated in just inside the fence, and the fence went right straight down the line, parallel with the house. Come to find out, the property line was a little bit skewed. Can't see my hands in the frame there. And it actually went from crossing the line to as much as like 8 feet over the line at the back corner. The house that my buyer wanted to buy had a side of the fence, one side over the line. And come to find out, the owner had installed that fence. The seller had installed it, but they had their own survey done first, and that surveyor's who messed up. So that's kind of rare. turned out to be getting permission from the neighbor. She said, I don't care. It doesn't really matter to me. It's all lined up, and I rent this property out. It's not the place that I live, and it's nothing that's a problem. So we got it in writing that they didn't care, and that satisfied everybody. So we were able to close. People were okay, they were okay, and they closed. But I don't know if you can tell here, but if you look at the little red checked line, dotted line there at the lower right in the slide, let's say that's the property line. What if it's not just a fence? What if it's an entire structure, the house, or a detached building like a garage? You're not moving that too easily, right? If it's over the property line, now we're going to have to solve it in a way other than moving it, hopefully, because that would be super expensive. So an encumbrance, some sort of a claim attaching to the real estate. It could be a fence issue of something over a line. Affects the title to the real estate. It's a right held by somebody else who is not the owner. And it could affect the value of the property because it has an encumbrance on it. The value could come down. It's not always about going over the property line. An encumbrance could be lots of different things. It could be a financial encumbrance called a lien. A lien is an encumbrance. You're putting a burden on the property. But while it would be a pain, sort of a problem, and it could lower the property value or the price being paid, it could still close successfully. So it doesn't necessarily keep the sale from happening. It's just that the sale would have this as a condition. It would be in there and attached to the property and acknowledge that this is an encumbrance that is on this property. So let's look at some other examples of encumbrances. A lien is put on the property because you owe money. You're putting the property up as collateral, or it's attached to the property so that whenever you do sell the property, that lien is going to get paid off. And there's lots of different entities that could put a lien on your house. Tell me some. Any ideas? Who might put a lien on the property?
Someone who does something to your house.
That's a good one. Yeah. A mechanic's lien is what that would be called. Like a vendor, like a roofer or plumber or an electrician. And there's some pretty specific rules about mechanic's liens and when they need to put that lien on the house. We're going to learn about that in a minute. What about another one? Tell me another one.
Maybe a pool installer?
Yeah, sure. That'd be another vendor. Yep, you got it. Carrie had some ideas here. The IRS could put a lien on the property. Ooh, let's all take a collective shudder, get a tummy ache. The IRS and also the state Department of Revenue. North Carolina, you don't pay your North Carolina income tax, you don't pay your federal income tax. Either or both could put a lien on your property because of the unpaid taxes. What about a lien that you would put on your property in order to even be able to buy it to begin with? Yeah, HOA could put a lien on. You got it, Gary. That's how we get the property. How many people can afford to buy a house all cash? Not many. More than you would think. It's surprising how many cash offers are out there, but not a bunch of people. And you have to get a mortgage to buy the property, and part of the conditions of getting that loan to buy the property is to put your house up as collateral, agree to put a lien against your property. If you don't pay your mortgage payment, you don't stay in the house. If you don't pay, you don't stay. That's something that's called a voluntary lien, because you did it on purpose. You did it voluntarily because otherwise you wouldn't have even the option of buying the house. So it's sort of a happy lien. You're glad to be able to put that lien on it because it means you can borrow the money you need to borrow to own it, to buy it. Those other ones, the IRS, the mechanics lien, the tax department, by the way, you don't pay your taxes, your property taxes, the city could put a lien on your property. Those are involuntary liens. We're not too thrilled about those. Those are sort of like a slap on the hand, bad, not a good kind of lien. So, Here are some types of encumbrances. We talked about an encroachment there at the bottom, crossing the property line, causes all kinds of headaches. Could be a driveway that's over the line, or detached garage, or a fence. We talked about liens there at the top, an unpaid debt using the property as collateral. And it could be a happy one. You did the mortgage on purpose, right? The mortgage is a voluntary lien. Tax lien because you didn't pay your taxes, or mechanics lien because you didn't pay your plumber or any other vendor. And then there's also an encumbrance called an easement. An easement. An easement is when you give someone else the right to access your property. A third party gets to use your property in some way. They can't come into the living room, kick up their feet, and watch the game, but they can walk across the yard there in the back to get to the green box where the cable lines are hooked up, or the gas line, or the power, right? Or the phone company. So an easement could be a power line or a power company easement, a gas easement, utility easement, and an easement could also be the driveway, a driveway easement to get access to the right-of-way, provide a right-of-way to the street. Here's some other encumbrances, and remember, an encumbrance is a burden on the property, so a deed restriction, a private deed restriction is an encumbrance. You'd rather it not be there, but it is, maybe. Maybe you'd rather it not be there. Maybe you're happy it's there because it says it can only build a 3,000 square foot brick house. And I want to keep my values consistent. I don't want to be in a neighborhood where I build a 3,000 foot brick house, but my neighbor across the street builds a 1,000 foot wood sided house. That might mess up our comparable sales and might maybe kind of harm the values. If we keep everything consistent in a bare minimum level of type of house and size of house, then we're going to have a better chance of the values staying solid. Restrictive covenants or encumbrances. Some other ones that we'll look at in future slides here in just a moment. Something called a lis pendens has to do with litigation. A writ of attachment, pending lawsuits, all of those could cause encumbrances. We're going to see what those are about in just a moment. But here's our voluntary and involuntary liens. The lien holder that has placed the lien on your property, they don't have the right to use your property. They're just putting the lien on the property so that they eventually get paid. So if you ever go to sell it, one of the things that you're going to have to pay out from your proceeds of selling is going to be to pay off those liens. That's when they're going to get their money. And that's why they put the lien on there, to make sure you couldn't sell it without them getting paid. So the voluntary lien is when you agree voluntarily, and the best example of that is a mortgage. And the rest of them are involuntary liens by law or by judgment, some sort of a tax lien or a foreclosure situation. There are two broad types of liens when we're talking about who gets paid first. If somebody gets in trouble financially, they're probably in trouble with more than one person, right? They probably owe more than one entity. We're going to talk about that when we come back from break. I'll see you in 10.
Video. All right. Ready? Yeah, I'm ready. Nice.
Yeah.
For what? What did I do?
Clean my room. It's so nice.
You're the best, buddy.
I'm so proud of you.
You are?
Yeah.
For what? What did I do?
Clean my room. It's so nice.
You're the best, buddy.
I'm so proud of you.
You are?
Yeah.
For what? What did I do?
Clean my room. It's so nice.
You're the best, buddy.
I'm so
Welcome back. Okay. So, as we left off, when somebody owes money to one person, they might possibly owe money to another, right? When things go bad, they get kind of bad across the board. So, there needs to be a system in place as to which of the various people someone might owe money to gets paid first. That's where this comes in. Specific liens versus general liens. A specific lien is a lien that is specific to the property itself. And a general lien attaches to both the property and also the person. Tell me an example, if you had to guess, of what a specific lien might be. Something that attaches to the property itself. What's specific to the property?
Like the mechanic.
Yeah, right. The mechanics lien is about work that was done to that property. That's a great one. Yeah, but who is probably in line before the mechanic, the vendor in a mechanics lien?
The IRS.
IRS. Think about the IRS though. The IRS, you owe money on your income tax. You didn't pay the proper amount for your income tax. Is that specific to the property? Or is that just specific to you, the person? The IRS is a general lien. It's in the category of general liens because it's not just all about your property itself. Yeah, they would put the lien on your property, but it's because you didn't pay your income taxes. Another kind of tax, though, that Gregor is on to here is the property tax. That is a specific lien because it's specific to the property, to the real estate. Good one. Now, Gregor also might have already known this, or he might have stumbled onto this. Property tax there's something special about property tax when it comes to lien priority. It is the, go ahead.
I thought it was the one that comes above all.
It
liens,
is. You got it. Perfect. Property tax is always in the first position. If you owe to lots of different folks, the first entity that's getting paid is the property tax lien. For your purposes in this test and on the PSI, property tax always gets paid first. That's the lien that is above all other liens. The real property tax. There is also a second position that is always just after property tax and still above all the other ones. And that one is a special assessment. A special assessment placed upon your property by the government. What is a special assessment? It's something that pays for a benefit that you're getting. For instance, maybe the government, the city decides that they want to put street lights up and down your street. And you get one right there in front of your property, you and all your neighbors, because you're benefiting from these street lights on this half a mile, quarter mile stretch of a street. You get to pay for it. They put a special assessment on you have to pay for. And maybe the entire project costs $200,000. All the people that are benefiting from these lights being there, are going to pay a monthly installment for a certain amount of time to pay off this special assessment. So that's levied against the property. If you're mad about it and you say maybe, well, gosh, I didn't even want the street light. Why do I have to pay for it? I'm not paying. If you go a few months without paying, it could eventually result in you having a special assessment lien placed on your house because you didn't keep paying. And then when you go to close on your house, you're going to have to pay it in order to close on the house if you ever decide to sell it. So what else is it about that number 1 and number 2 spot? The property tax and the special assessments are in the number 1 and number 2 spots. That's kind of interesting. Who wrote the law about liens? The government. Who are we paying the taxes and the special assessment to? The ones who wrote the rules and the laws. Imagine, funny how that works, right? So the taxes are number 1, special assessments are number 2, and they are both considered specific liens. Think of it as 2 buckets. the bucket of specific liens and the bucket of general liens. I need to add bucket pictures to this slide. Okay, so a lien is a non-possessory charge against the property providing security for a debt, right? The lien holder doesn't get to use the property, but they put this lien on it so that if the property ever gets sold, it can't close until those liens are paid off. Specific liens get paid before general liens because they are specific to the property. They get paid first. The liens in the bucket called specific liens are in a superior position to the general liens. So let's look at specific liens. Real property tax and special assessments are in number 1 and 2 positions. After that, and in no particular order, these are not in order, guys. Besides the real first one and the second one, all the rest of them are in a different kind of order, but not this is not the order they're in. They are all specific liens, but they may not get paid. The mortgage may not get paid before the lien from the mechanic's lien or the commercial broker lien. All of these things are specific liens, but they get paid, except for the first 2 positions, they get paid in order of recordation. What does that mean? When you record a document at the courthouse, that means you're taking it to the Register of Deeds, you're putting it on the public record, accessible to everybody in the whole world. All you have to do to see what is recorded in your county or city is to go to your county website or go to the actual in-person courthouse or government building, look in the Register of Deeds department, and it has every document that has been put on the public record. What sorts of things are put on the public record? Liens, also deeds. You can see what your neighbor, what their deed looks like. You could go, if you just type in whatever county you're in, Alexander County ROD, Register of Deeds. You'll find the Register of Deeds department online for that county. And then you can plug in the address and see the deed firsthand, or the other things that are recorded. So when I say something is recorded, that just means it has been given to the government building, to the Register of Deeds department, probably gets a stamp acknowledging when it was recorded, and now it's out there for anybody to have access to that information. In our business, the deed needs to be recorded after closing in order for the keys to go to the buyer and the money proceeds to go to the seller, and the money to go to you for the commission that you are owed as well. So, order of recording. Did the plumber record their lien because the owner didn't pay them? Did they record their lien before the roofer and before the electrician? Then they're going to get paid first before those other 2. It's in order of the one who got there first and recorded it. Commercial broker lien, I think, I don't know. We may not. We'll see that in a minute. I'll wait for the slide to explain that one. Okay, let's look at the mechanic's lien. Oops. And see how that works. So when we're talking about a mechanic's lien, it's not your car mechanic, right? It's any sort of contractor, any sort of vendor or contractor that does work on the property. And there's a timeline requirement for that person, that vendor, that person who did work. They have to submit the lien in a certain number of days. So let's look at this timeline. August 3rd is when the plumber started doing work on the property. That's an important date. Not that specific date, but the date when the work was begun, or when materials were first delivered to the property. That's the date that we key everything off of. So the date of first work or first materials. And let's just say in this example that on August 17th, the plumber stops working on the property because she gets the feeling that this owner is not in good financial position and may not pay her when she's done. So she doesn't want to put any more of her time and effort into it. She stops. So August 17th is when she stops the work. Within 120 days from in orange there, after the last day the mechanic person, the plumber in this case, did the work or furnished materials, she's got that 120-day window from the last date that she did any work or gave materials, during which she can file the mechanic's lien at the courthouse. She hasn't exercised the lien yet. She's just put it on the public record that, look, I'm getting a funny feeling. I want to put a lien against this house just in case they don't end up paying me. You with me? So that's what you need to know. They have to file the mechanic's lien within 120 days of the last date of work done or materials provided. Now, hopefully I counted 120 days right. That's not the point, but somewhere around that, December 16th is my guess, after August 17th. You have to file within 120 days of the last day of work, but once you file it, your position in line against all the other people that might be owed money depends on the day you started your work. You with me? So if the plumber filed within that 120-day window, her place in line is August 3rd. Let's say that the electrician, the owner had an electrician out there, and that electrician started with their work on August 7th. And the electrician stopped their work, and then they applied for or filed a mechanic's lien. Who's going to be paid first? This plumber or that electrician? It matters about the date you started the work. So the plumber started August 3rd. The electrician started August 17th. Oh, is it not showing up clearly? Some of you, it might be blurry. Let me see if I can fix that. Can you see it better? Is that better? More clear? Okay, good. Thank you for letting me know. A Zoom share works better for clarity, apparently, than the other thing I was doing. Good. So it can be confusing. That's why I wanted to give you this graphical representation. So when do you have to file your mechanic's lien? Within 120 days of the day you last did work on the property. When can you exercise the lien? Within 180 days of the day you last did work. So you might file the lien just to have your place in line locked in, but you don't ever exercise the lien because maybe they do end up paying you, right? So those are the two requirements, 120 days and 180 days. 120 days to file it and 180 days within which you would have to exercise the lien. So as long as that plumber can prove she filed the lien within the 120 days from the last day of work, which she would have paperwork proving that, then she retains the right to pursue court action against the owner to enforce the lien if she needs to. And so this court action pursuit, exercising of the lien, would have to be initiated within the 180-day window from the last time she did work. Now, in red there at the bottom, her place in line in relation to all the other potential lien holders is based on the date she began the work. So the test question could be, could give this elaborate list of everybody that's owed money, and the mechanic's lien is going to matter as to their place in line as to when the work was begun, right? Not when they filed, but when the work started. They would have something, they would have to have something in writing that proved when they went out there and started the work or first provided materials. I think if I don't already, I will put this on in your class slides, in your class file, in your class Google Drive, just so you can have it for studying later. So that's the mechanic's lien and the priority the lien priority there. It's all about when they started the work, but they have to have filed it within 120 days of the last day of work and then exercise the lien within 180. Now, wouldn't it be nice if you listed a property? Oh, let me tell you a story. This is a little better. I once listed a property, and it was back around 2010. And what we learned in 2010 is that people might owe more on their house than they can get for their house because the values were lower. Not probably going to happen that much these days because values are up pretty high. But back then, when I went on a listing appointment and told somebody what they might get from selling their house, sometimes I had to give them the bad news that, sorry, Mr. Seller, you're not getting any money when you sell your house. It's not worth more than what you owe. You're going to have to bring a check to sell and close on your house. You're going to have to pay $3,000 to sell your house because you owe more in expenses and your loan to the bank than it's worth. So I did that. I listed a house and I explained to the seller, look, looking like from my math and my estimate of what your house is going to sell for, that you might have to bring some money to the closing table, maybe like $1,000 or so. Is that okay? Do you have that available? And he said, yeah, no problem. I can do that. I'm retiring. I want to sell this house, buy a truck and buy an RV to pull it with, or buy a truck to pull the RV with, and go across the country and just live out of the RV. That's all I want to do. That's my retirement plan. And I said, okay, great. And at the time, it took a while to sell houses. Not like today. 5 months later, we finally got an offer that really worked. We'd had some offers, but this one was finally a good one. I went over to his house to get the paperwork signed. We had already worked out over the phone, verbally back and forth, counter offers back and forth. I was going over to get it all locked down in writing. And when I got there, he pointed to an envelope on the table and it said Bank of America Short Sale Department. Short sales are something we're going to learn about in the finance chapter. And that's when you owe more to your lender than you can get from the sale of your house. And so you need to ask your lender's permission to please let me pay you less than what I owe you. Would you let me do that? And back then they were all over the place. They had to do, there were short, I didn't even know what a short sale was until 2008. From 1996 to 2008, never had to do one. But all of a sudden we had to do them all the time. And it's a process that we'll learn about later. Well, I needed to have disclosed that this was a short sale all of this time. He never told me that he didn't want to do it, that he had told me he would bring $1,000 to buy his way out of his house. Come to find out, he had also gone ahead and bought the truck and went ahead and bought the RV. And he ended up letting that deal go away because he said, you know what? I talked to an attorney and they explained to me the amazing benefits of declaring bankruptcy. And I'm going to declare bankruptcy and let the house go to foreclosure because I get to keep my truck and my RV because it's a place to live. And I get what I wanted anyway. I get to ride off into the sunset. But guess who gets the shaft in this scenario besides whatever creditors he has? Good old Neil. I could have maybe tried to pursue him and get the commission. I brought him a ready, willing, and able buyer. But here he is not accepting that offer and deciding to declare bankruptcy. And I've done work for 5 months in good faith. Wouldn't it have been nice if I could have put a lien on his house to get my commission? Well, I couldn't, and I can't, and that's not a thing. But if it had been commercial, in the commercial side of brokerage, you can do that. For whatever reason, you get the feeling that you're not going to get paid. If you're doing commercial real estate, you can put something called a commercial real estate broker lien on the property. For commercial only, not residential. It protects the broker's commission. You have to have a written agency agreement that spells out, look, they hired me to sell their house and now they're screwing me over, so I'm putting a lien on the property. And it could be a sale that you're getting, that you're not getting your commission from, or a lease. So it just protects the broker's commission. It's a North Carolina thing. So just know that. Commercial broker's lien, commercial real estate broker lien is for commercial side only. You have to have a written agency agreement. It protects your commission in the event that that seller is trying to cheat you out of paying it. I didn't end up getting paid on that deal with the dude in the RV. I just wished him nothing but the worst and moved on with my life. But you win some, you lose some. So all of those things are specific liens, specific to the property. Things that are general liens apply. Yes, they are put against the property, but they also stick with the person too. So all of those specific liens pretty much get handled when you sell the property. There are some things that even though you sell the property, you still owe. IRS is one of them, right? North Carolina Department of Revenue is another one. So you might not be able to pay the IRS everything you owe them with the sale of your property. And therefore, they could stick the additional that you still owe them, attach it to you, and now you're going to have a deficiency judgment or some sort of a thing or anchor around you. And so good luck getting a loan on a car or anything else later, because that's going to show up on your credit report. A court-ordered judgment lien because you got maybe a lawsuit situation, and part of the case resolution was that you got a lien placed against you, the person. General liens are paid after the specific ones because they don't only apply to the property, they apply to all of your property, both real and personal. Car tax is a good example of a general lien. So how do liens affect real estate? They could certainly lower the value. You could sell your property with 3 or 4 liens on it. You don't have the money to pay them. You need to sell your property, but it has like 4 liens on it. And a buyer could buy it and you could sell it. It's just that buyer, you better believe, is not going to be willing to pay full market value if they're buying the property plus having to pay off your liens once they own the property, right? So you can still sell it. You just need to disclose what those liens are. And you're probably going to have to sell it for a discount because they're the ones that's going to have to pay off those liens. So does an encumbrance or a lien prevent the transfer of property? Could you still sell it even though it has an encumbrance or even though it has a lien against it? You sure can. Oh, well, I mean, yes, you can sell it. So no, it does not prevent the transfer. A grantee cannot refuse an easement as an encumbrance. A grantee can agree to assume responsibility for paying the lien. You could still sell it, even though it has these things. You would just handle it with some paperwork. So here's that lien priority situation. North Carolina is what's considered a race state, meaning race to the courthouse to record whatever document you have so that you get your place in line ahead of everyone else. A pure race state. First to the courthouse to record their lien is the one who gets paid first. In always the first position on the right here, real property tax. In always the second position, special assessments, both from the government, by the way. And then after that are the specific lien bucket items in order of when they were recorded. And then after all of those, finally, are the general liens, again, in order that they have been recorded. So let's take a look. Let's look at this little test, little quiz here. A property owner has several liens filed against them. What's the proper order of repaying these liens? So we have the IRS, a lien issued July 15th of 2017. We have a North Carolina Department of Revenue issued March 9th of 2017. We have a mortgage issued February 24th of 2019. We have a mechanics lien from August 4th of 2020. And we have property tax issued on October 31st of 2021. Which one's going to be first? We'll start there.
Property tax?
You got it. Property tax. Is there any special assessment lien in this list? No, not seeing any special assessments. Okay. What would come next? Of the remaining 4, which ones are the specific liens versus general liens? Specific liens include the mechanic's lien, you got it, and also the mortgage, right? So out of those two, which one is getting paid first?
Mortgage.
Yeah, the one that's oldest, right? The one that got filed first. And then finally, the general liens are the IRS and the North Carolina Department of Revenue. Which one of those is getting paid first? That's how it would look. Property tax first, the mortgage second, because it was filed before the mechanic's lien. And then those are both specific liens, all three, in fact. And then the last two are general liens. But the one who filed first, who got recorded first, I should say, is the North Carolina Department of Revenue, which was March 9th, and the IRS then in July. Property tax is always first, then specific liens in order recorded, then general liens in order recorded. And then don't forget, if there were a second mechanic's lien in this list, it would need to be in order of when the labor or materials were first done or delivered. So that's how it wouldn't be pictures, but they would write a test question with each of these items mentioned, and you'd have to make a note and think, okay, which one came first? Is the IRS ever going to come before the mortgage? For our purposes, no, because the IRS type of lien is a general lien. The mortgage is a specific lien.
Can you go back to the slide with the order?
That one?
The other one. The before your little pop quiz.
That one? Got it. Good? Okay. Another kind of lien is a writ of attachment, meaning a court order of some sort has attached a lien to it because of some legal action that you were involved with. Pretty simple. Just know the definition. Writ of attachment involves a court order being attached, which creates a lien. Now, we're done with liens. We're talking about encumbrances again, though, and this is just another type of encumbrance. A lien is a type of encumbrance. A private deed restriction is also. A seller can put restrictions on the property. They could say only 2,000 feet, always full brick, and only single story. There's a neighborhood in Concord that's pretty much like that. You can only build single level brick, all full brick houses, at least I think 2,000 square feet. Or an HOA might restrict what color the front door and the trim is, or what style of fence can be used. No chain link fencing, only pickets or vinyl, and no more than 6 feet tall. What if the zoning requirement for a fence height is 8 feet and the private deed restriction for fence height is 6 feet? 6 feet. Which one wins? Which one do you have to follow and you're limited by?
The stricter one?
Yeah. Isn't it tempting to think, well, gosh, it must be the zoning one. That's the government one that you have to follow. But no, we see this in several parts of this course when there are two requirements, like maybe one is a federal requirement and one is a state requirement, or one is a state and one is a local government. Doesn't matter the size of the body of it, the entity. Doesn't matter if it's federal or not. The stricter one is the one you have to follow. The stricter one wins. That's the one that takes priority. So if the zoning rules and laws require no more than an 8-foot fence, and the local one says no more than a 6-foot fence, then your fence is going to be 6 feet, no more than 6. Doesn't matter who's saying it. It matters which one is stricter. The term lis pendens means that there is some litigation affecting the title to the property. And it clouds the title, which means when the attorney does a title search, they're going to notice find out that, oh, there's a problem here. This title is not clean and clear. The deed to this property is not pristine. It has a smudge on it, has a cloud on it. But you can still close. You would just have to do some extra stuff. So a lis pendens deals with pending litigation. Pending, lis litigation. You could still sell it, even though it has that on there. You're probably just going to have to take less for it, or do some other financial thing to make up for it. When you have a title policy, a title problem, there's a process involved. So the order of events for the notice of quiet title suits, meaning, oh, there's some clouds on the title. This title to this property, the deed to this property has some issues that need to be cleared up. The first step is that lis pendens is filed as recorded notice that there's some sort of litigation that might affect the title, that might end up being put against the title. The next step is that there's a court hearing and the judge says, makes a ruling. They decide, okay, is this claim against this property valid or not? And if they decide it's not valid, they're going to do what's called quieting it. They're going to remove it. They're going to say, nope, there's no problem here. We're cleared up. This is a clear title. Then they'll make a court ruling, clearing that clouded title, perfecting the title. Now your problem is resolved. You don't have an issue anymore. You might have had to do certain things to clear that up, and you've proven that it's all cleared up and in good shape now. So that's the order. Pop quiz. Who gets paid first from the proceeds of a sale, also called a transfer? When you're transferring the title, that means you're selling the property or giving it to someone else. Who always gets paid first in that lien priority? Property tax first. You could have also said the government, because they're the ones that you're paying because of the property tax lien. And also number 2, right, for special assessments from the government. You could have a special assessment that's not from the government, by the way. It could be placed upon you by the HOA because it's an assessment within the neighborhood. I once had a townhouse listing, and they had not managed the money there. The HOA had not taken care of the money too well, and they lost track of when the properties were going to need roofs. There were probably 8 or 10 buildings, each that had 4 or 5 townhouses, and they needed to put roofs on all of them. And that was a lot of money. So they put out a special assessment. Anybody that lived there had to pay $250 extra a month on top of their normal homeowner dues to cover the roof assessment. That wasn't a government one. That was within the HOA. So that would be a specific lien, but it would not be the second position lien. The second position type lien is a special assessment put upon it by the government, right? Another kind of encumbrance is this guy, an easement, giving a third party access to the property to maintain things like utilities, power lines, gas lines. It doesn't create an estate, neither a ownership or a leasehold type of estate. It's just giving access so that they can take care of the utilities or whatever it might be. Anybody seen these boxes? Can you see that okay, by the way? Still seeing everything pretty clear?
You're still sharing your screen, so you're kind of small up in the corner.
Oh, that's okay. As long as you can see the slide nice and clear. Thank you, though. So an easement appurtenant. Remember the word appurtenant. It runs with the property. So it's benefiting the land or providing access. You're giving an easement to give access. It's built in because you have to, right? That utility company needs to get to that green box, or the driveway issue that we're going to talk more about in just a moment. So it runs with, if we look in the lower right there's the main road. And then the gray lines there, the gray bars are the driveways of both of these houses. The black are the property lines and the little red houses. So obviously this thing labeled the dominant estate, where that green arrow is, their driveway is going across the property line because it's the only way they can get out to the road. So they have an easement appurtenant. You might also hear it called a appurtenant easement for that driveway, a driveway easement. The servient estate is the one that the easement is going over, right? They're being burdened. They probably would rather the neighbor's driveway not be there, but it has to be, and they have to allow it. And the next person that owns this servient estate is going to also have to allow it. They can't cut it off and say, well, that was the last guy. I'm special. I don't have to give you this access. No, it's part of owning the property. So know these two terms. The one who is getting the benefit of this driveway going across that neighbor's property is called the dominant estate. And the one that has to put up with it is the servient estate, right? A couple more terms. That's all this slide is about, is those terms. Another kind of easement, we've got this easement appurtenant, but you also have something called an easement in gross. An easement in gross, it's not attached to the estate in land or belonging to a person by virtue of their ownership. It's benefited to an entity or a person or a company or the government. It's just a personal interest in or the right to use the land of another. Purely personal, and once the grantee dies, it no longer exists. It doesn't run with the land. It's attached to the person or the entity. You could think about a railroad company. They have an easement in gross for those train tracks. When that railroad company ceases to exist, that easement is no longer needed because the railroad company doesn't exist anymore. The railroad tracks might still be there, but the right to have them there is no longer there. You could take them up. You could get rid of them. Not needed. They're attached to the railroad company. They're not attached in part of the land itself. How do we set up an easement? That brings to mind a couple of words that you're going to see a lot in this course. The words express versus implied. When you see the word express, think that you're expressing yourself, right? You're saying something about yourself. You're saying your intentions in this case. How do you say things? You could say things by speaking them out of your mouth. You could also say things or convey them by writing them down. So an express agreement, in this case, an express easement, is just an intentional easement. It's like, this is what we want to do. It could be something verbal. It could also be in writing. But when it comes to an easement, it's better that it's in writing because now you have something you could put out there and have proof of. So the word express means you're being intentional about what you want to do. The word implied means that you're not saying what you want to do. You're just acting a certain way and making them assume how things are based on your actions. Not as good. And when it comes to contracts in this state, an implied contract is not worth the paper that it's not written on, right? An implied contract is not something expressed. It's not something that you have declared. It's just the way you're acting. Yeah, they seem to want to buy it. They're acting like they want to buy it. They've never said they want to buy it. They're acting like it, though. Not good enough. An example of an implied contract is something that you've probably done in the last week. You yourself have probably engaged in this concept of an implied contract because you probably went into a restaurant or a coffee shop and you sat down and you ordered something and they did not ask you for a bank statement or a proof of funds or a pre-approval letter. You ordered food, they brought it to you. They even let you sit there and eat it, all while you didn't even pay for it yet. It's an implied agreement that you're going to pay for it once you're done. Now, you might go there and sit down and you might just say, let me get that seat, that booth right next to the door. Because when I'm done eating this, I'm going to see how fast I can sprint to my car and drive away because I'm not intending on buying anything, right? I'm going to dine and dash. Probably not, right? you're sitting here with me now. You didn't get caught. I'm assuming you've not dined and dashed anytime ever. You got there. You could go to the most fancy restaurant. They're not asking you for a proof of funds letter. Do you really have the money to buy a $200 meal? Couple of meals, couple of steaks for $50 each, and drinks and this and that, and $200, please. Do you have that? We need to see what's in your wallet. Nope. You get to go there. You could order the food. They might make you wear a shirt and a tie or something, but you get to order the food and eat it, and that's called an implied contract. An express is something that you're intentional about. Yes, if you went into that restaurant and said, I can afford this meal, that would be you and an express contract. They would look at you funny. They might call the cops, but you don't have to do that. The implied one is okay too, is good enough. In this case, an implied easement is something that could exist because it's needed. It's necessary. There's a circumstance or facts in place that require it. So an implied easement is allowed, but the difference between that and an express easement is it's necessary for providing access, for instance. You could also have an easement that is put in place through operation of law. Ever heard of the term eminent domain? Term eminent domain has been the subject of movies and books, and it's also something that pops up in the news from time to time. The concept of eminent domain pretty much means, look, if it's for the public good, then we can take over somebody's property. We need to pay them for it. We would pay them fair market value, but we need to turn this 2-lane road into a 4-lane road. And in order to do that, we're going to have to cut the front yards down by half of all those houses on this stretch of road. We're going to take over half of all of their front yards so that we can put 2 more lanes, one coming, one going, because it's for the public good. It's for the good of the public. Therefore, we can condemn the property through eminent domain because it benefits everybody, sacrificing just a few. They can't just take it, though. They have to pay you fair market value for it. So with eminent domain, it's probably pretty typical that the owner isn't too happy, and they probably disagree as to how much that fair market value is. They probably would rather it be more than what it's declared to be. But that's the process. It's condemnation through eminent domain. That's an operation of law that could create an easement. Another one is this last one, and it's pretty weird. We're going to get into that in just a moment. Prescription easement because of adverse use. Adverse. The word adverse. Is that a happy thing or a negative? Positive or negative? Adversary. An enemy. Yeah. Thumbs down. Right? So prescriptive easement due to adverse use is when somebody basically tries to, basically squatting. It's essentially squatting. Somebody could own and take over your property if they do a certain number of things in a certain order for a certain amount of time, and they could make a claim to the court and say, I did this for an amount of time, therefore this is mine now. I want official title to the property. And they could win. So let's look at that in just a second. But first, let's look at an easement by necessity. That's the case of the driveway. It is legally required in North Carolina that you cannot have a landlocked property. A lot cannot be landlocked. Law requires owners have to have access to the public roadway. So having a right-of-way going over one person's property to give access to another to get out to the road is an easement by necessity. It's necessary, right? To get that legal requirement satisfied. Now, here's the adverse possession thing. The prescriptive easement for adverse use. Showing you this pretty picture of the ocean because the acronym for it is OCEAN. OCEAN. An owner could lose their property to somebody else if that person uses the property for a certain amount of time in certain ways. Think about it this way. Let's say that you inherited some land in the mountains. And from my understanding, I don't think any of you are close to the mountains. I think we're all sort of like Greensboro, Charlotte, or east. So it's far enough away that it's not convenient. You don't even like the mountains. You'd rather go to the beach, but you got this property. You got it in a will from some great uncle once upon a time. And over the course of 20 years, you never went and visited it. You might have paid the tax bill, and that wasn't a big deal because it wasn't that much. But that whole time, since you never went there, you never knew this, but it turns out one of the neighbors was using your property. Maybe they were using it to farm on every year for 20 years. They were using it openly. They weren't trying to hide it and not let anybody see. In fact, everybody who lived around there saw them using it and just assumed it was their property because they saw them using it openly. They used it continuously every year for 20 years. 20 is a key number here. They used it exclusively. It wasn't them and everybody else in the neighborhood. It was just them. Exclusive. They used it actually, and they used it notoriously. Meaning, if you had known better and found out that they were using it, you would not have wanted them to use it. You would not have let them use it. It was without your knowledge. If all 5 of these things are met, that person, after 20 years of doing this, could petition to the court to give them that property. And they could win. If the judge said, did you use it openly, continuously, exclusively, actually, and notoriously, and 20 years worth, then okay, sure, it's yours. If there's no cloud on the title, then it's 20 years that it would take. If there is a cloud on the title, then it would only take 7 years of doing it openly, continuously, exclusively, actually, and notoriously. It's weird. I know. And I'm sure every state has something like it. I'm sure you've heard of squatting. And it sort of reminds me of that concept, basically. But that's it. That's what you need to know for prescriptive easement. Also, adverse use is another term for it. And that's the acronym that's attached. They could ask you on the test, they could give you a scenario of like different groups of people or different people who used it. And if they were to say, John, a neighbor next door, used it to grow crops in years of plenty of rain. And then the last question, the actual question of this would be like, which of the parties mentioned would have a claim to go to the court and acquire this property through adverse use? Well, not John, because he didn't use it every year. He only used it on the years that had plenty of rain. What if it's another person that used it for 20 plus years and openly and continuously to, I don't know, maybe even they built something on it. Maybe they kept horses on it or something. And as long as all of these 5 bullet points of this acronym are met, and it's that, especially the continuous one for 20 years with an unclouded title, they're the one. That's probably the answer. That's the one who could have a claim to gain ownership of this property through adverse use. What's a way that the owner could destroy this whole thing for that person who's trying to acquire it? If that owner were to find out it was being used and give them permission to use it for some reason, why would they do that? Well, by doing that, they've gotten rid of the notorious part. Now it's no longer notorious. The owner gave them permission. The owner could rescind the permission immediately, but that set them back to 0, basically. Maybe in year 19, the owner stumbles across the fact that somebody's been using it all of this time, and they say, you know what? I'm not up there anyway. So what? Good for you. Go ahead and use it. Well, now they can still keep using it, but they might be disappointed because they're back to 0. Right? They had 1 more year to go and they could have actually owned it, but the owner gave them permission to use it. The notorious element is now violated. Therefore, they might still be happy because now at least they have permission to use it, but they're not going to be able to own it. They'd have to it's impossible at this point because the owner has given them permission, right? How can easements go away? If you don't need them anymore, the parties could say, this is no longer needed. We're getting rid of this easement. It could be that the one who has the easement buys the property that the easement is on. So it's no longer needed because they bought the property itself. So if you have that driveway situation and you buy that servient lot, then you don't need the easement there because you own all of it. You own both of those lots, right? It could also be that that dominant estate releases to the servient estate. They say, you know what? I don't need this anymore. You don't need to have this anymore. What if in this image, at the top of the slide here, there was another road? There's just another road up there, and maybe it had woods. Let's do it this way. Let me see here. Oh, I'll do that later. I don't want to mess up our screen share. But if there was another way for that dominant easement to get out to a right of way, like another road, and they just always had the driveway that's being shown here, maybe they decide, you know what? Let's get rid of this driveway to the front, and we'll just make a driveway going out the back of the property to that other road because it's closer to everything anyway. It's more convenient. In that case, they wouldn't need this current driveway with the green arrow. So that would be releasing it to the servient estate. Or it could be that the easement is abandoned by the one who holds it. Another situation could be a license, and we'll talk about that when we come back from break. I'll see you in 10. welcome back. Is everything still clear? Can you see the screen clearly? The slides and stuff? I'm looking at faces. Let me know if you have any trouble, but hopefully you
Hey,
can.
you're still on mute.
Oh, thank you. There we go. Is everything still clear? Can you see those slides okay? Okay, good. All right. So, another way that you could give somebody permission to use your property, but it is not an easement. It's like the lowest thing on the list. It's the lowest amount of usage ability they could possibly have. And that's called a license to use your property, like a fishing license or a hunting license. In other words, maybe you have some acreage with some woods, forest area, like I do. I've got a couple acres of wooded area. Just so happens that my neighbor operates a small business out of his shop. And it's a very pleasant small business. What will happen is between October and Christmas time, December or so, during deer season, pickup trucks will pull up to that shop and throw dead Bambis out from the bed into the shop for him to cut up into steaks and carve up, and he processes the deer, right? So we're in the city limits, but yet still a little bit country out here, okay? And there are a lot of hunters, obviously, and they see the land and the woods behind our properties. And one day I got a letter in the mail, and the guy said, "Hey, I'm a bow hunter, and I was just curious, would you give me a hunting license to use your woods for bow hunting?" At the time I had 2 dogs. I just didn't want to be in a situation where I didn't know how good of a hunter he is. I didn't know how safe he might be. And so I basically didn't give him permission. Because if an arrow had shown up in the side of one of my dogs, then I would have ended up guilty of murder, and I didn't have time for that. So that hunting license is what we're talking about. If I had a lake or stream, I could have given him a license to fish out of my pond, my lake. So a license can be revoked. I could say, yeah, okay, you can do it. And then the very next day I could say, you know what, never mind. You can't do it anymore. He could not assign it. I could give him the license, but it's only for him. He could not give it to someone else and assign it to another person without my permission. I would have to say, yeah, okay, they can come and hunt as well. And it's not an encumbrance. It's not even as strong as that. And it doesn't run with the land. It's only for an amount of time for that guy. That's it. So it's the lightest possible way that some third party could use the property. We talked about encroachments. Anytime something is crossing the property line, like an improvement, a fence, a driveway, the best way to discover an encroachment is to have a survey done. So as a broker, you're helping a buyer purchase the property, and they say many times the buyer doesn't want to get a survey done because they are tired of writing checks. They've spent a bunch of money already. They had to make an offer, and they had to put up due diligence money and earnest money. Then they had to apply for the loan, and they had to write a check for the appraisal. That's another $400 or $500. They had to get the property inspected, and that's another $500 to $1,000. And by the time the survey comes up in the conversation, in the order of things, a lot of times they say, you know what? I got the one from the seller. I'm okay with that. The problem with a buyer using the seller's survey is that if there ends up being a problem about an encumbrance or an encroachment like this, then the title insurance that they're going to have to get for the property won't cover it. They're going to have to pay for moving that building or that driveway or fixing that encroachment problem. They'd have to pay for that themselves. The insurance wouldn't cover it. If they were to get their own survey at the time of purchase, then their title policy, their title insurance policy would in fact cover it. Why? The reason the title policy would cover it is because part of that process is they would require a survey to be done, during which they would find out if there's any encroachment problems. That's why we get surveys done. We want to make sure. What does a survey show you? It shows you, yes, the little drawing of the house in relation to the property lines. There's other things on that survey. There's lines that are dotted within the property line, and those are called setback lines. You can't just build your property right up to the line necessarily. In certain cities and certain towns and areas, there's requirements of how far back from your own property line you're allowed to build an improvement. Is it within the setback line limits? It's also revealed on the survey that the property is in a flood zone. When we get to the chapter on insurance, we'll learn about flood insurance and flood plains. But is there one? The survey is going to find that out. The surveyor will discover that and make a mention of it on the survey. They're going to show where the fences are, if there are any sort of easements. They're going to show that there's a utility easement across the back, and they have all sorts of little notes all on this drawing of the property. An encroachment is something that would cloud both titles, the title of the one that's doing the encroaching and the one that is being encroached upon. The scariest horror story about surveys not being done when they should that I've heard was a case where the buyer agent did not suggest to the buyer to have a survey done. And wouldn't you know it, turns out the well that served the property was not on the property. It was on the neighbor's property. And this was not discovered until later, after the buyer owned the property. And guess what? It's not their well because it's not on their property. And they had to get a new well dug that is on their property. And guess who ended up paying for it? The agent. Because it should have been something they caught. They didn't suggest a survey, therefore it wasn't discovered. Therefore, the owner decided to dig their own well on their property instead of having to depend and get permission from the neighbor. And guess what? It had to be an extra deep well because sometimes you don't get enough water pressure if you go down the standard depth. It had to be like triple the depth or something crazy. It ended up costing $60,000 to put in that well. $60,000. Even if you sell $1 million houses, that's still more than one commission check, right? And at the time, this was years ago, average sale price of $200,000 back then, maybe. You're talking about you might get $3,000 from any one sale, maybe after taxes and everything else. So yeah, that's a career killer, right? I think they got on some sort of a payment plan. Somehow they were able to actually do it, but they had to pay a lot over time. There is something called, Ben asked, is there insurance? There is an insurance policy that you get in this business called errors and omissions that might kick in at some point for that sort of thing. But that might have been past the scope of what that coverage would handle. And, it kind of scares you from wanting to even do the business sometimes when you hear those horror stories. But the lesson to be made there is suggest that they have it done. It could have been that the buyer wouldn't have chosen to get one done, even if the agent had suggested, but the agent just needed to go on record and say, hey, I think you need a survey. I don't want one. Okay, great. Initial right here saying that you turned it down. You need that. There's a form for that. It's called a professional services disclosure. You don't need to know that for our class, but you'll learn about that in post-licensing. That's where you basically ask them, hey, you need to have inspections, whatever it is that you want to suggest that they get, and have a record that they turned down or not. They can either initial that they're waiving it or they're initialing that they're going to get it. That's how you know what to help them order, right? Especially in this case where they're saying, I don't want to get it done, and you know that they should. Now you have it in writing. Next year when they call you and they say, hey, you never told me to get a survey, and now I've got this thing that's happening. Oh, well, here, let me send you the document over that shows that I did, in fact, suggest you get a survey. See, there's your initials. There's your signature, right? Don't sue me, bro. I covered my bases, right? Okay, pop quiz. Dominant versus servient in real estate. Can the servient property owner refuse to allow the easement across their property?
No.
They cannot. Good job. Good job. And with that, we are finished with chapter 2, guys. Let's move straight on into 3. Three involves our first little bit of math. I just heard some people's stress levels increase, but that's okay. We're going to get through this. It's okay. We can do it. There we go. So let's talk about property taxation and how that whole process works. The timeline, how taxes are calculated in North Carolina. There's a national question and a state question related to taxation that will show up on the test. You need to be able to calculate taxes for another chapter in this course, chapter 21, about closing the transaction. And in real life, it's on our to-do list to make sure that our client is paying the right amount in taxes for prorating the day of closing. In other words, the taxes are due at one particular point of the year. Depending on which part of the year you closed, you have the closing, depends on how you calculate the taxes. The seller owned the property from January 1st all the way up to the day of closing. It is their responsibility to pay that portion of the taxes for the year. How much is that? We're going to learn how to calculate it. And then the buyer is responsible for the rest of the year. How much is that? And how does it need to be reflected on the closing statement? That's what this chapter is about. So, we've seen everything okay, good. Taxation is that governmental power to fund its functions, right? Your taxes pay for that. Pay for what? Pay for schools, pay for roads, sidewalks, things that are being used by the public. And those taxes come from property taxes and other things too, but we're talking about real estate taxes, real property taxes. The word for it is a Latin term called ad valorem, at value. You're being taxed at the value of the property. Now, the tax value is what we're working with when we calculate the taxes of a property, not how much it's sold for. Those are probably not the same things. Probably not the same number. Tax value versus sale price, probably different. And it's probably different to benefit you, the owner, because usually the tax value is lower than the market value. And we're happy about that. Because, yeah, I'd rather pay taxes on a lower amount, especially these days when you have to pay so much to buy the property. So, you might see the term assessed value show up. That's the same thing as tax value. Assessed value is tax value. And all of that is also ad valorem value. At the value, it's based on whatever the tax value is. The thing that determines how we handle the calculation of taxes and the collection and what the dates are, when it's due, all that fun stuff, is a piece of legislation called the Machinery Act. The Machinery Act is what regulates real property taxes. It's regulating the machinery of this tax process, right? So what is it that sets up the taxation system for real estate? The Machinery Act. You need to know that one. There's a timetable. Certain times are involved here. Now, the tax value of your property does not get reassessed every single year. And so over time, depending on a certain area and how much development it sees, how much is going on to raise the values, houses are worth more now than they were 5 years ago or 10 years ago. Well, the government knows this, and so every 8 years through this process called octennial reappraisal, they reset everyone. They reappraise everybody's tax value to allow for the fact that the values go up over time. In Charlotte, in the Mecklenburg County area, I think it was maybe 2 years ago, maybe 3 years ago, that this particular thing happened. This octennial reappraisal took place. And everybody in Charlotte was moaning and complaining because they found out from the government, from the city, that their tax value went up. That means their tax bill is going to go up because the tax bill is calculated by using the tax value. They went up like 20% in a lot of cases. They went up a lot. So that was a pretty significant amount. And some of you, anybody own a house or make a house payment? You actually make house payments versus rent. So you know that you make your house payment after the month you live there, right? You get to live there first. You pay a house payment in arrears after the time you live there. So you live there in October and you pay for having lived there in October, you pay that on November 1st payment. The opposite of rent. In order to live there in October, you have to pay rent on October 1st, right? Also, with taxes, I just blanked. What was I getting around to? Oh, your mortgage payment could include it. You might have it set up with your lender that you send in your house payment, and that includes taxes and insurance. Anybody familiar with that idea? Principal, interest, taxes, and insurance. So part of your monthly payment is going toward your property tax. Well, in the event of this octennial reappraisal, your lender might send you a notice and say, hey, your taxes are higher now. We need you to give us more money to put into the escrow account so that we have plenty to use when it's time for the taxes to be paid. So it can cause a good bit of frustration. But every 8 years, tax values are reappraised. That's called octennial reappraisal. It's required for that to happen. It could be that there's a uniform adjustment made every 4 years. That one's called a horizontal adjustment. It doesn't have to happen, but it's available. It's in the law to be allowed to take place if the government decides, look, values have gone up so steeply that we can't keep up. We need more money to handle the additional need for schools and roads to be fixed because there's a lot of potholes, because there's more traffic, because there's more people who have moved in. Therefore, we need to do a horizontal adjustment this fourth year to get more revenue coming in from taxes so that we can keep things nice, keep things able to support the extra people that come in. The tax rate, the rate at which you are taxed. That one could be adjusted every year. That one could change every year. It is published every year. So the tax rate is adjusted annually. The tax value is adjusted every 8 years and possibly every 4 years, depending on the need. What if you live in the city limits? The white shape here is the county limits. And then, of course, the city within the county. There's lots of cities in the county, right? Let's say that you live in the green area, whatever that city is. Are you going to, and let's say that the tax rate, the city tax rate is 80 cents per $100. And the county tax rate is 20 cents per $100. We'll see what that means in a minute. If you live in the green area, in the city limits, what rate are we going to use to calculate your taxes? Just one of those, or both of them? Both of them. Because you can't live in the city without living in the county, right? You're in the county because you're in the city, because the city is in the county. Does that make sense? So if on the test question it says the property is located in the city limits, then you're going to need to add together both the city and the county rate. But if the test question says the property is outside the city limits, then the only rate you need to use and worry about is the county one. You can ignore the city one. You'll see, and that'll make more sense when we actually start doing the problems in a minute here. Timetable. In July, is when the tax rate is set. And it might stay the same from one year to the next, but that's when it's going to change and be published. Here's what the new tax rate is. That's going to be revealed in July of every year. In August, the bills are mailed out because the taxes become due on September 1st every year. In other words, you can't pay the taxes until September 1st or after. Even if your lender is the one paying the taxes for you because you've been sending them extra with your house payment, they're probably not paying it in September either. They seem to be paying it in November and December, and that's okay. The first date that you could possibly pay your taxes every year is September 1st. The last date that you can pay your taxes every year without a penalty is December 31st. So you have, and there's no penalty for paying it in that timetable. You're good. Whether you pay September 1st or December 31st, that is the allowable time frame. If you go past December 31st, though, you're going to have a tax lien filed for those unpaid taxes. Now a lien is going to show up on your property. There's that tax lien that we talked about. That's the number one position. As of January 5th, that's the deadline for you to pay your past due taxes. And then January 31st rolls around and you still haven't paid, your property is going to be listed and you'll be publicly shamed. So-and-so at this property has not paid their taxes. The taxable property is listed that it's overdue on January 31st. So know those dates. Hopefully you've done a little screen cap on those. Here's what they look like on a timeline. January 1st of a given year is when a tax lien would be filed from the previous year's unpaid taxes. January 5th is the deadline to pay any past due taxes. You're just going to have more to pay the further you go past this date, right? More penalties will add up. January 31st is when the property will be listed and they're telling everybody that your taxes are overdue. All of those are bad, negative things, so they're in red, right? Red alert. Every year, though, July is when the tax rate is set. August is when the bills are mailed out, and September 1st is the first date that you could possibly pay your tax bill. That's when it's due and payable. September 1st is important because that's how we decide what we need to do with the taxes when we prorate them to get ready for a closing date. It depends on where in the year the closing happened, where in relation to September 1st the closing happened, or I should say when. When in relation to September 1st the closing happened depends on the three possible ways that we could handle taxes mathematically on the closing. And we'll learn about that in just a second. This tax lien thing, they could eventually result in you losing your property. If you don't pay your taxes, the lien goes on the property, you could eventually lose the property. It could be foreclosed upon. Those tax liens attached to the property on the first day of that listing period, even though the tax isn't due until later in the year. In other words, January 1st, the taxes are listed, they're attached to the property. You know it's going to be coming. You don't have to pay it yet. You can't pay it yet. So that tax lien attaches to the property January 1st. January 5th of the next year is the last day to pay the bill without a late penalty. And if you pay it past January 5th, you're incurring extra penalty. You'll be paying more. January 31st, we know this already. So note here in the red, if the previous year's taxes were not paid by December 31st, it's possible for a property to have two current tax liens between January 1st and 5th. The one for the upcoming year, the one that we're not worried about because we have all the way, we can't even pay it yet until September 1st. And then the one from the previous year, the one that we are worried about, because now the clock is ticking and you don't have very much time at all. Eventually, the government could decide to foreclose on the property. There's no formula necessarily. It depends on their whim as to when they might want to possibly foreclose. It would possibly even be like a whole year or two worth of, or more, worth of late taxes, unpaid taxes So it's not like an immediate super fast thing necessarily, but the longer you go past the 5th, the more you're going to have to pay in penalty. Remember this race state concept? We just a note that the tax lien is the first thing paid. That's the first position, number 1. That's what we're talking about. This is the thing that was referring to. All right, the calculations. Calculations are level 3 because you have to actually do stuff, right? You have to work on it and crunch the numbers and do the math. We're going to handle the math in a couple of ways. Most of the math in this course is nothing more complicated than a basic algebra problem. So like under that word linear method, if I ask you this question, if I said 2 multiplied by x, the letter x, what is x? 2 times x equals 6. What is x? Solve for x. You would automatically know in your head because you're an adult. You buy things at the store and you can probably count back change, right? So you'd probably know, well, 2 times 3 is 6. So x equals 3, right? You just did algebra because of your life lessons, just because you get along day to day in life, right? But it can get a little more challenging when these numbers get bigger. So if you're comfortable with math and the linear organization, like you learned when you went through algebra, 2 times 3 is 6, 6 divided by 3 is 2, 6 divided by 2 is 3, then embrace that, do that, great. You do you. But if you need some graphical help, that's where this T formula or this circle formula concept comes up and can be useful. So you'll see sort of this T shape, and the number on top is what the 2 numbers on the bottom add or equal up to when you multiply them. So the 2 bottom numbers multiplied by each other equals the number on top. And so we're going to reduce most of the math that you have to do in this class to this. Anytime, if that's something that you're just kind of rolling your eyes, oh, I don't want to do that, that's fine. Do it the way that you can do it. You can probably do it either way. And if that's the case, do it your favorite way. But we're talking about this circle formula or this T-bar formula is a way for people that are just math phobic. It kind of gives them a graphical representation. If you know where to plug it into this circle, then you're going to automatically know what you need to do with the numbers, because the thing on the top divided by one of the things on the bottom equals the other thing on the bottom. You with me? And the 2 things on the bottom multiplied by each other equals the thing on top. Now let's apply it to something. First of all, the tax rate. How are taxes calculated? They're calculated by using a rate. A certain amount of money per something else. And across the state of North Carolina, there's 2 potential ways any given city might give the rate. They're not going to do it both of these ways. They'll do one or the other. In Charlotte and in Concord, Cabarrus County, where I am, we do the right side, the dollars per $100. Anybody know which way that your city, your town is? Just shake your head. You may not. I know some counties out toward the east use the other one, the one in red, the mill rate. So on the test question, you'll see one or the other. It'll either give you a tax rate in number of mills, or it'll give you a tax rate in dollars per $100. When it's the dollars per 100, that means that you're taxed this many dollars or cents per every $100 of tax value. That's the understood verbiage that's in there. How many dollars are you paying in tax per every $100 of taxable tax value? So when the test question gives the tax rate to you in dollars per 100, let's say they said that the city and county tax rate added together is $1.70, 1.7, $1.70 per $100 of tax value. Then you would take that 1.7 or $1.70 and you would divide it by 100. to get a decimal number, to get that same number in the form of a decimal. And you're going to use that to do your calculation. This will make sense when we're actually doing one. I'm just kind of giving you a little preview. If it's mill rate that they handle taxes in, or on the test question, they say the tax rate is 11 mils. That's how they'll say it. 12 mils, 11 mils, 9 mils. You see the word mils? You think in your head, okay, if it's a mill rate, it's not 100 that I'm going to divide by, it's 1,000. 1,000. I think of it from my memory aid is like like $1 million. It's like 2 sets of 3, and there's 3 zeros in 1,000. Right? It's silly, I know. But mill rate, 11 mils divided by 1,000 gives you the decimal you need to use to do the calculation. If the rate they give you is dollars per hundred, take that $1.70 or whatever it is, divide it by 100 to get the decimal version that you need. It'll make sense in a second. Here it is. Let's say that they on the left, the mill rate for the property tax rate is 14 mils. You would divide the 14 mils by 1,000, and that gives you a decimal number, 0.014. If you plug it into a calculator, if you plug in 14 divided by 1,000, that equals 0.014. Now look over on the right. What if instead of mill rate, they give it to you this way? They say the property tax rate is $1.40 per hundred. Then you'll take that $1.40, or 1.4 is another way you could look at it. 1.4 divided by 100 is 0.014. So notice that. It just so happens that the mill rate of 14 mils and the dollar per hundred version of $1.40 per hundred is the same decimal number, right? So it's going to be either or. They're going to give you the rate in one of those ways or the other. So here's a typical problem you might look at, you might see. If the assessed value is $257,000, what's another word for assessed value, by the way? Assessed value is tax value. Yeah. It's what the tax value has been assessed at, right? So assessed value is $257,000. The market value or the sales price is probably more than that, and that's okay. Sometimes they'll give you the sales price in the transaction, and they'll tell you the assessed value is 80% of the market value, and you're going to have to calculate what is 80% of the sale price in order to get here. But I'm not being that mean to you yet, right? They might be mean to you on the test. Let's just start with the tax value and get this down first, and then we'll go from there. Assessed value, also known as tax value, $257,000. That's the price or the value on which your taxes will be based. The tax rate is going to be given here in mils. It's 14 mils. So what is the owner's annual tax bill? What are they going to have to pay every year in their taxes for property tax with this information? Let's take the mill rate of 14 divided by 1,000 to get the 0.014. Now we have a decimal number we can work with. We multiply that rate, the decimal version of the rate, by the tax value or assessed value, and 0.014 the rate times the tax value of $257,000 in your calculator will reveal $3,598. That is your annual taxes. So on another piece of paper in your notes, you might want to keep a list of circle formulas. And so this one would be, it looked like this on the left. Annual taxes or annual tax bill on the top. Market value, it would actually be annual taxes on top, and then tax value on the bottom, and then the tax rate on the other side of the bottom. I'm going to be writing some stuff for you in just a moment. We'll write it out together. It'll make more sense. All right, we looked at one using the mill rate. Now let's look at one using a tax rate in dollars per hundred instead of mills. So we'll keep the same tax value, just to be nice. Assessed value is still $257,000, but this property is located in an area that gives tax rates in dollars per hundred of $1.27. For every $100 of tax value, you have to pay $1.27 in taxes. Okay? What is $1.27 per hundred written in a decimal version? Just divide it by 100. You'll notice that when you divide a decimal number by 100, you're essentially moving that decimal place over 2 spaces to the left. If you see the yellow, 1.27, the difference between that and the red number is we move the decimal over. That's the easy part. That's why the metric system is nice. We still don't use it in America, but if you do, you just move decimals back and forth. And that's all you really have to do. You don't even need a calculator once you get used to this idea. $1.27 in a decimal version is 0.0127. It's that decimal number version that we need to plug into this step 2. So 0.0127 tax rate, the decimal version, times the tax value gives us a tax bill every year of $32.63.90. With me? We'll do this a lot. So if you don't get it, right now, it's okay. It's normal. It'll be repetitions, and it'll make more sense. Let's look at a little more like what you'll potentially see on a test. They could say that the assessed value is 85% of the market value. In other words, the tax value on which you are taxed is not the same as what you paid for it. How much is it? It's 85% of the market value. The market value is another word for sale price for our purposes. So the market value is $574,000. Can we calculate the assessed value? Now that we know market value is $574 and the assessed value is 85% of that. If we just look in the lower right, multiply 85% of 574, that gives us our tax value, right? I should say annual tax value. Sorry, or not annual tax bill at all. I should say tax value. Let me fix that so it's not too confused. There we go. That's better. There we go. That's better. So the market value, $574,000 multiplied by the decimal version of the tax rate. Oops, sorry myself. Market value, $574,000 times the 85% gives us what our tax value is. Now we have something to work with along with the tax rate and to find our annual tax bill. So we know our assessed value, tax value, is $487.9. Carry that over. Step one. Figure out what the assessed tax value is. That's what we just did. We used our market value times the percent of market value is the tax value to get it. The next step is going to be taking that mill rate and turning it into a decimal. And then the third step is going to be using that decimal number multiplied by the tax value, the assessed value to get the annual tax bill. So that's what's happening. We're now moving on to step 2. We take our 487.9 tax value, and we multiply it by the mills. The problem said that the tax rate is 9 mills. 9 mils divided about 1,000, 0.009 times tax value is an annual tax bill of $43.91. Good, good. What if instead of the mill rate on this one, we just did it with the mill rate of 9? What if the problem instead was like changing a couple things around? The assessed value is 75% of the market value. Different problem. The market value is $497,000. Okay, we know we're going to need to figure out the tax value information. This is the lower left. 75% of the market value, tax value of $372,750. The next step, take that tax value and the tax rate, and multiply them together to get the tax bill. But first, we need to make sure we're using the right tax rate. So what does the problem say? It says the county tax rate is 67 cents per $100, and the city tax rate is 17 cents per $100. But the house is located outside the city limits. So which one of these rates, both added together? What is it that we need to work with on this problem? Not in the city limit. So the city rate is irrelevant. We don't need to work with the city rate. Only rate that applies to this house is 67 cents per $100. Right. So we can ignore that city tax rate. So we're going to use 67 cents, and we're going to turn it into a decimal by dividing it by 100. Lower right. 0.00067 times the tax value of $372,750 gives us our annual tax bill of $24.97. Right. I'll do it where I'm walking you through it on the screen here in just a second. Here's what it looked like graphically, right? City rate is 700, county rate is 67 cents per property is in this little green dot there on the upper left. That's where the property is located. It's not in the city. Only in the county. That's why we only use the county rate. If the property had been the red pointer on the far right, then we would have to add 67.17 because that's the full combined tax rate that it will be calculated on, right? So again, depending on which way, what kind of rate they give you, you need to know what you need to do with that mill rate. You're going to divide that now by 1,000 to get the decimal you need. If it's a dollar per $100 version, you're going to divide that 0.17, whatever 100 per 100, divide it by. How do you know to divide it by 100? It says so. It's a dollar per. So it's basically divided by 100. 100. It's right there. What you do with it, what you divide it by, in the name of the rate per 100. Some formulas that we'll run into. We've handled these already. We've been working with these. The market value, also known as the sale price, perhaps. If you multiply that by what market value is the tax value, that gives you the tax value. And then assess the value times the tax rate gives you the annual tax obligation, annual tax bill per year. And then sometimes, especially when we get to Unit 21 closing math, you're going to need to know what your monthly tax is. So you'll take your annual taxes. I think the last one we calculated was $24.97 was that one that we calculated in that last example. Let's say our annual tax bill is $24.97. How much is that per month? You just divide $24.97 by 12 to reveal how much your taxes per month are. Because you might need to calculate monthly taxes for various reasons. And then if you need to know how much your taxes are on a daily basis, you're going to take that annual tax bill and divide it by divided by 360. I know. They're not 360 days in the year. But the real estate commission is to you nice to you and they're saying we're not trying to test you on math. We want to test you on real estate math. And so let's take an element of complication out. Every month is not the same number of days. Let's pretend that they are. And for your purposes, pre-licensing, every month has 30 days. Write that in your notes. Every month has 30 days. Even February. For your purposes in calculating various things we're going to be dealing with in this class. Well, if every month has 30 days and there's 12 months in a year, then 12 times 30 means that every year has 360 days. So when you need to figure out a daily thing, you'll divide by 360 in this class. When you get to post-licensing, it returns to normal. You have to deal with what it's really like in real world. For pre-licensing, you have that 30-day months across the board. Let's do a couple more. Market value is $675,000. The problem is telling you that the tax value, also known as assessed value, is 85% of that market value. Also, it's telling you that the tax rate in this area is 12 mils. So what is the annual tax bill for this owner in dollars? How much are they going to owe every year? All right, first step, figure out the tax value. We know the market value, and we know how much of the market value is the tax value. 85% of it. So what's 85% of 675? Our assessed value is 573,750. That first line. We also know that tax rate is given in mils. So I'm just giving you this. This is like the non-circle formula method. Those of you who like good old linear algebra, same thing. Except it just looks a little different. So you people who maybe like that better, this is for you. 12 mils needs to turn into a decimal number. 12 is divided by what? Anytime it's mils, you divide by 1,000. 12 divided by 1,000 is the decimal 0.012. Second line there, last line there on the slide. Now we multiply 0.012 by 573,750. There's our annual tax bill of $68.85. We good? Maybe after what is this, the fifth repetition, starting to maybe see some recurring themes, maybe make a little more sense. Here's the last one, and then we'll do some kind of free form, and you'll see me writing it out. Market value on this problem is 734,500. Tax value is 70% of the market value. The city rate is in dollars per hundred. It's 23 cents per $100 of tax value. County rate is 98 cents per $100 of tax value. Property is located inside the city limits. What is the annual tax bill in dollars? It's in the city limits. So we need them both. So what's 23 cents plus 98 cents? $1.21. That's the tax rate. We're working with. What is our tax value? Well, what is 70% of 734.5? That's 514,150. Right. Now we take our 514,150, multiply it by our rate given in a decimal, $20.21 divided by 100 is 0.0121. Multiplying those two together gives us our annual tax bill of $62.21.22. Okay. Looking at faces. Seeing some hesitant acceptance. Okay. I kind of get it. Yeah. Okay. That works. Let's do it this way. Do it another way.
seeing
Are you
my
seeing my
iPad
iPad screen?
I think you are.
I think you are. Okay, good.
Here's how it's going to be.
Here's how it's going to be for
on the
you
test.
on the test.
And
Forgive my penmanship. I've been told I write like a doctor.
But I've also been
But
told
I've also been told I write like a
serial
serial killer.
I'm not sure which is
the compliment.
But in both
But
cases,
in both cases, I'll try really hard to make it legible. So
it could be that
the sales price
is
is
$157,000.
Let's go back a few years. The good old days when we sold houses for $157,000.
It could be that
the assessed value
is
75% of the
sale price.
sale price.
Sale price is
just another term for market value.
And then the
tax rate
is 15
mils.
Did we have enough
information to calculate the annual tax bill?
I think so.
So
I'm going to pause.
Be quiet,
And let you guys
work that out.
And after this, in fact, I give you another minute or so on this, and then we'll just start our break. We'll talk about this when we come back from the break. Let me just give you an 11-minute break instead of a 10 one. You can spend a minute of that working through this, and then I'll see you in a little while. Just come back together at 8:48. 40 minutes or so. There we go. Okay. What was our first step? At a sales price of 157. The assessed value is 75% of that, and the tax rate is 15 mils. What's step one?
On the assessed value,
There you go. So how do we do that?
multiply by 0.75.
There you go. 157 times 75 and the percent sign. That's all you have to do. And there is our assessed value. 117,750. Over here, we're going to put the rate. But it's the rate, in this case, divided by 1,000 because it's mils. So we take 15. When you see the number 15, it is understood that that is actually 15.0, right? So there's our decimal. To divide 15 mils by 1,000 is just to take that decimal and move it over 3 places. And essentially that's 0.015. If we do that, 15 divided by 1,000, there it is. Just a faster way. You don't necessarily have to use a calculator for every little thing. Now that we have our decimal version of 0.015, let me write that better. 0.015. Multiply that by the 117,750. And there is our annual tax bill amount. We okay there? Good. Okay. I have one of these tutorials on impactbrokercoach.com. It's the YouTube channel. So if you need to see it again, just a walkthrough, same kind of a thing, except a narrated walkthrough. That is it. That's 3. Let's move on to 4. There we go. I'll bring it up on your screen here in just a second. Okay. That should be right. Unit 4, it's called transferring title to real property. How do we get rid of it? How do we give it to someone else or sell it to someone else? The bulk of this syllabus section is level 2. That's why the little 2-bar battery is up at the top. I'm slowly getting the levels added to these slides. So bear with me. Eventually I'll get them all updated there. Our objectives in Unit 4 is to see those different methods of transferring title, talk about what the essential elements of a deed are, talk about types of deeds, a little bit more math, something called excise tax, and then the title insurance process, getting it, how the title search process goes, and what is this thing called title insurance process. So when we talk about transferring our property, whether we're giving it to someone or we're selling it to someone, the term alienation comes up. And so alienation just means alienating yourself from the property. That's all that is. You're either giving it away or you're selling it. You're getting rid of it. Separating yourself from the property is alienation, just another term that you're going to see. In order to give or sell a property, we need to make sure we're giving or selling the right property. So we need to be accurate in describing what the property is, right?
So describing land, the legal description of the property is an essential element of the deed. We need to make sure that we're selling the right thing. When we describe property, there's lots of ways to describe it. What we need to put on a deed, the kind of description that needs to go on a deed, is a legal description. The address, by the way, is not a legal description. A street address is informal. That's just basically where you mail things to. But that's not good enough for a deed. A legal description is required. That's an exact description of real property. There are several ways to provide a legal description. And we talk about 4 different ways. There are 3 of them that we use in North Carolina, the ones here at the top. But then there's one of them that you could run into on the national portion of the PSI exam. And that is not used in North Carolina, but it is used in real estate in other states. Therefore, you could see it. But thank goodness you don't need to do any sort of calculations about that version. That's called the Government Rectangular Survey System. It was created in the founding father era. I think Thomas Jefferson is actually whose idea it was. What's special about those colonial days? The original 13 colonies were established first, right, on the eastern coast. And then they started making their way west, going out into the new west, right? And so an idea was formed. Let's make sure we organize that as we're developing, as we're taking things, creating towns in those western states. Let's do it in an organized fashion. And that's how the Government Rectangular Survey System came about. It divides it up into grids, into grid sections. And we'll see that in a moment. But all you really need to know about the Government Rectangular Survey System for the test is the words, the vocabulary words associated with it. So we'll see those in a moment. For North Carolina, the accepted ways to legally describe property are these 3. The best possible method is called meets and bounds. This is all testable stuff. Meets and bounds is the best method for describing property in North Carolina. It's the best legal description method. Another method is to refer back to a plat map. A plat map is just literally a map. It looks like a big survey. It's like a big version of a bunch of surveys put together of a bunch of lots and how they are situated into the whole neighborhood. So it's divided up into lots and block numbers. So the whole block of lots, like for instance, maybe 1 through 20. And so which lot is it? It's lot 7 of block 435, whatever that is, right? So referring to a plat map that is recorded at the Register of Deeds. Remember when we said recording something just means registering it and recording it at the Register of Deeds. Now it's on the public record. It's available. You can go look up the Register of Deeds website of your given county and find plat maps recorded there of your very neighborhood that you're sitting in. So referring to one of those recorded plat maps is a legal description that is allowable in North Carolina. And then another one, the third one, is referring to a previously recorded deed. Saying, hey, if you want to know what the legal description of this property is, go look at that deed from 4 years ago. The deed located at this location in this book and this page number that we recorded back then, it's the same property as it was back then. Go look at that one. That's what this property is that we're selling today. Same one as that one. So any of these 3 are allowable. The meets and bounds one is the preferred one. It's the primary method used in all of the original 13 colonies, pretty much the East Coast states, the original ones. And when you see it written out in words, it looks like the left. And it looks pretty cryptic and weird, and it's fun at parties. So you literally are writing a description of if you were to go out to the property in person and start walking the boundary lines, beginning at the northeast lot corner, thence, oh, here we go, from, that's a word we don't see every day. You're not seeing that word on Instagram. Thence South, 16 degrees, 42 minutes, 22 seconds. Those are all direction settings. East, 100 feet. Thence, another 33 degrees. Basically, meets and bounds means distance and direction. So when you see 100 feet, that's distance, right? 16 degrees south, that's what direction we're going the 100 feet in. And that's all it is. So what are some terms associated with the meets and bounds method of legal description? Distance and direction, right? Distance is meets, direction is bounds. Another thing you'll see in this paragraph, not this one, but some of the older ones from way back when, like those original ones back 200 years ago, they'll say, starting at the rock at the corner of this street and that street, go to the tree and then turn 16 degrees west and travel 200 feet to the rock outcropping. They used what are called monuments. Monument is something immovable. And they didn't have much to go on. You know, they had rocks and streams and intersections back then. Today, our monuments are basically maybe 1.5 feet or 2 feet of an iron rebar that we knock and nail into the ground. The stake. It's not the stake that has the flag on it, because that's just wood and it can be moved, but it's an iron bar in the ground. That's the monuments we use today. That's how we know what the corner is. That northeast lot corner mentioned here is probably got a metal stake, or a metal bar in the ground. An iron rod or something that you could find with a metal detector. If you're trying to find old property lines, the surveyor will probably have a metal detector, and they'll start looking around in the spot they assume it's going to be. And they find it and they mark it with a wooden stake with an orange flag on it or a red flag on it. And then they have that yellow tripod looking thing with a scope on top, and they sight it to the other guy who's holding a yellow stick with a flag on top. And that little device that they're looking through tells them how far it is and what direction they're heading. And that's how they survey a property. So this paragraph of words on the left is a description of the image on the right. This thing labeled point of beginning in the middle, so that top middle thing, point of beginning, that's where you start. The other thing about the meets and bounds method of legal description is that it has to be a closed shape. Once you're done describing this thing in words, it needs to come around all the way back to the point of beginning. So the point of ending is the same as the point of beginning. Otherwise, you have an open shape and you don't have an actual full set of perimeters, right? Boundaries. So this is what they did. They started at that point of beginning. And look in the paragraph, it said beginning at the northeast lot corner. That's the northeast point, is that point of beginning. Go south 16 degrees, 42, 22, and there it is. On the right, 16, 42, 22. And travel 168 feet to the next point, the next monument point, or the next stake in this case, and then go in this other direction, 156 feet, and you continue all the way around till you get back to that point of beginning. And it just so happens that they have some extra information here. They've calculated that it's 0.46 acres on this lot. This particular lot is 0.46 acres. That's the meets and bounds system, distance and direction. And it's just a written out set of words that describe the distances and directions. Got to have a point of beginning. That's testable. It's testable stuff, which is also the ending point. That's where the measurement starts and stops. Monuments are the places where directions change. Those are fixed objects to establish those boundaries. Meets, that means distance, like meter. Think meter. And then bounds is direction. There's our point of beginning. There are the monuments on those corners, and there's meets and bounds along the way, showing degrees for direction and feet, in this case, for distances. So terms associated with meets and bounds. Let me know. What are some terms associated with meets and bounds?
Distance and direction.
Distance and direction. What else? Point of beginning. You got it. Monuments. Now, we're done with this one. Let's look at the one that doesn't apply to North Carolina. Notice all the colonies plus Texas are whited out because those use meets and bounds. The rest of the U.S. uses the government rectangular survey system. It's developed by the government in 1785 to establish some sort of a system of organization for the New West as the various territories were established. It looks like a big grid system, sort of like this. It's the whole thing laid out into a grid pattern. And the north and south lines, the up and down lines, are purple. The word to refer to those is meridian and range. Those are meridian lines and range lines. The principal meridian is the one in the middle. We okay? Did I hear a question? There we go. Let me take care of that. Okay, good. So the meridian line, the principal meridian line is that middle line. And that's for this given area, the very middle of this collection of townships. So we've got what runs north and south, meridians and range lines. What runs east and west, baselines and tiers. So the yellow on this in this image, the main horizontal line is the baseline. The other horizontal lines are range lines that also run east and west. So they make a grid pattern. And you'll notice in the far right, that little kind of aqua teal colored square, a square in teal of a whole bunch of little squares. That entire teal square is a township. It's a township. And so all of these other things it's sitting next to are also townships. They are all townships together. That's what the meridian and baseline and ranges and tiers are dividing them up into. It's dividing the land into these townships. What is a township? It's a perfect square with dimensions of 6 miles by 6 miles. The side of a township is 6 miles long. So it's a square of 6 miles by 6 miles. And if you divide that into 1 mile lines, that township, each of those little squares in this teal township square is called a section. It's the various sections of the township or the town. This is a 1 mile square shape, and a township is a 6 mile square shape. You with me? These are all the terms you need to know. So, how many sections are in a town? Okay, a section is a 1 mile square. So there are 6 miles to a side. So 6 times 6. There's 36 sections in one town. Right? You'll notice the little orange square, maybe, amongst that teal one. That's a very special. Actually, I need to bump it over one. It needs to be over one more to the right. That's number 16. And I'll show you on the next slide how they're numbered. That's the one where they decided to always put the government buildings. That way, no matter what town you rode into, on a horse, of course, you'd know where to find the courthouse or the schoolhouse or those government-related buildings. The sheriff's station, police station, sheriff's office. Okay, so if a section within that town is 1 mile by 1 mile, how many acres is in a section? I'll show you how to do that in a little bit, but that's going to require you to know how many square feet are in an acre. So let's do that. Here we go. Okay. 1 acre. Anybody have an idea of how many square feet are in an acre? 1 acre. How many square feet? The square feet in an acre is 43,560. 43,560 square feet. That constitutes an acre of land. How do we remember that? My favorite way to remember this is 4 little old ladies driving 35 miles an hour in a 60-mile-an-hour zone. It just sticks. You could also remember it this way. 4 plus 3 is 7, and 5 plus 6 plus 0 is 11, and the convenience store called 7-Eleven. But I like the old lady method. So you just need to burn that in your brain, because you're going to need to know how to convert square feet into acres and acres into square feet. All right, if we know that, let's take a different direction here. If we know a section, not a pretty square, let's pretend that's an actual square, is 1 mile by 1 mile. How many feet are in a mile? Happen to know? Any runners here?
5,280.
You got it. Somebody's running. 5,280 feet on a side.
No, I've just seen Remember the Titans.
Oh, well, that's good enough. That works too. So if we need to come up with the square feet in a 1 mile by 1 mile dimension shape, then multiply 5,280 times 5,280. Spoiler alert, it's going to be a huge number. Oh my gosh, it's 27,878,400 square feet. How do we convert square feet into acres? I'll show it to you drawn out here in a minute, but the short answer is just divide it by the number of square feet that are in an acre, divided by 43,560. So one section of a town has 640 acres. That's how we got that. Because on the slide that we saw in a moment ago, which is right here now, a section of 1 mile by 1 mile, 640 acres. That's why. That's how we get that. Okay, so let's look at that teal shape again. Here's our town on the left. And it's 6 miles by 6 miles. How big is a town? 6 miles square. 6 miles by 6 miles. And then the number 14 block here, the section 14, is what I'm focusing in on the right. A section is one of those miles by 1 mile. So a town has 36 sections of a mile times a mile. How are the towns numbered? They're always numbered such that the first section in a town is the upper right, and the last section of a town is the lower right. I know all of you are going to be able to identify with this because this is such a real world thing that we all deal with. The way they decided to number a town is because that's how you plow a field with a mule, right? Who's with me? We all did that this weekend, right? So that's how that works. We start on number 1. We go down 1, 2, 3, 4, 5, 6. It would be stupid because remember, you're holding a plow in your hands being pulled by this huge animal. Wouldn't it be dumb to go all the way back to 1 and then move over and do the next row? You do that with your John Deere lawnmower because it's just a lawnmower. But if you had to walk it behind an animal, you'd want to do the short way. 1 through 6, go across to the next row, and then back to where you came. And you just work your way, stair-stepping on down. That's how that happened. By the way, another interesting little fact is, how big is an acre? Why is it 43,560? What an arbitrary number. An acre is pretty much a football field without the end zones. So imagine that in your head. And that's how much land that one person can plow with a single mule in one day. Another one that's completely relatable. Oh, one man, by the way, the women they're not allowed to do this, of course, because it was 300 years ago. Not in real life, just kidding, just a joke, okay? That's how the townships are laid out. That's kind of where the acre thing came from. So let's look at this orange shape on the right. That's what a section actually looks like. And here's some good news. You don't need to worry about all of these weird directions. You used to. In this class, they used to say the house is located on the southwest corner of the northeast square of section 14 in township such and such. And you had to figure out which part that was located. So you don't need to worry about that. If you see the northwest quarter, northeast quarter, that's just so that you can figure out where in the section the property is located. But you don't have to do that as for your test anymore. All you need to know about Government Rectangular Survey is the terminology. The range lines, the meridian lines, the base lines, the tier lines, that a town is 6 miles by 6 miles and a section is 1 mile by 1 mile. Another little interesting point is this one I think I already told you. Number 16 is where they always put the government services buildings. That's where the courthouse would be located, sheriff's office, schoolhouse. So all of those things are sections in this township. So what are those terms associated with that Government Rectangular Survey?
Meridian lines and baselines.
Mm-hmm. More? What else?
Township, section.
You got it. Yep, that's what you need to know. So we've talked about meets and bounds, which is our preferred way, our best way in North Carolina. We talked about the Government Rectangular Survey, which is not at all used in North Carolina, period. Let's look at the other ones that we use in North Carolina. Referring to a previously recorded deed. It might say that these are kept, by the way, in books. Big books. You can go to the Register of Deeds in your local courthouse, and it's just this room full of these black leather-bound books. Well, probably fake leather. And it says book 413, page number 97 is where you'll find this deed. Book and page number. When you see book and page, that's what it's talking about. So where's the deed where we need to look for the legal description for this property that's selling today? It was referenced in a previously recorded deed from 3 years ago. Go look it up in book and page such and such, right? By the way, this is what a deed looks like today. Just so happens that this one is a general warranty deed. We'll see what that means probably next time we meet together. I don't think we'll hit that tonight. But there it is. The sections at the top relate to when it was registered, when it was recorded, and how much the excise taxes were. And then it pretty much starts from the halfway point down, identifying the county, the people involved, the amount of considerations. And it's a couple of pages. So that's the other kind of legal description. Meets and bounds and referencing a previously recorded deed. And then here's the third and final one. Referencing a previously recorded plat map. So I told you that a plat map kind of looked like a bunch of surveys put together. And there it is. Each one of those lots has its own survey, but here are all the lots in relation to each other. And you can see maybe vaguely in the upper right corner, plat book such and such, page number such and such. There's the book and page I mentioned. And then it's just divided up into blocks. On the far left upper portion, that's block E. And then right in the middle, kind of to the right, is block D. So I can't read the lot numbers from here, but each of those lots, what does it look like? About 2, 4, 6, 8, 10, 12, about 18 or 20 lots in block D. And then block E has probably about that same number of lots in it. So the property in question is lot 15 in block E. And go look at it on the plat map, would be kind of how that's worded. So a plat is just a map showing the location and boundaries of all the lots in a subdivision. That plat has to be there for every subdivision, by the way. If you're a developer, you cannot close on the sale of that lot unless it is recorded. It's illegal to do so. They could get in trouble. We'll learn about this later, but they can go ahead and get the property under contract if they have a preliminary plan, but they can't close on it until they have a finally recorded plat map. So the preliminary plat map is good enough to get somebody under contract and agree to buy it. But before they can close, this thing has to go from preliminary to final version. And if you think about it, that makes sense. You wouldn't want to buy a piece of land only to find out that it wasn't the exact piece of land you thought you were buying. So it better be the final recorded version that before you put your name on the dotted line and officially consummate the sale. The informal references are all the other stuff. The legal descriptions are what we just learned about. Everything else that refers to a property is just informal, including the street address. If you ever spent time looking at tax records, you might have run across a 9 or 12-digit number called a tax parcel ID number, maybe a 10-digit number. Tax parcel ID is not a legal description. It is an informal reference, so is the street address not good enough to be put on a deed. Now, when we list a property and put it up for sale, we just put every possible thing we can find. We definitely want the legal description, but we're also going to use the address. We're also going to include the tax parcel ID number. We want to be full disclosure, full transparency, make sure people can find this thing in all the various places there is to find it. What's it known as in the tax records? Tax parcel ID number. That's not a legal description. That's okay. Put it in the contract anyway. But definitely also include the legal description. And the city name, any street address is pretty much just telling you where the post office is located in that town, right? Survey shows a variety of information. We talked about a survey a minute ago. Here's one that you can actually see. And it's a little corner lot in this case, the house. It's identified as a 2.5-story frame dwelling. I don't know if you can read that. It has a little sidewalk out the front. It has another sidewalk out the back going to the right to the garage. It's like a freestanding detached single car garage. And there's where the driveway is. Looks like the driveway is off of Livingston Avenue, and the front sidewalk is out off of Stratford Place. So what else is in this survey? They've identified some trees, but that's not the important part. The main thing is the house, the garage, the sidewalk, the driveway, and I don't see it. There's a couple little references here and there, but within the boundary lines, oftentimes there's going to be those setback lines I mentioned. I don't think there is in this particular survey, but it's showing the lot dimensions, of course, but it's also showing setback lines, flood zone, if there is one, and the lot and block information that we saw in that last one. Any sort of easements or encroachments are also going to be referenced. In fact, if that one-story garage, were over that dotted line, like a little higher up in the picture, that would be an encroachment over the property line, right? And that would be revealed by the survey. They would draw it so that it's over that property line, and then we would know that we have a problem. We have an encroachment. So, if you're a broker in the transaction and the survey comes back and you get this in your possession and you go talk to your client, many times you're seeing this survey for the first time together at the closing table. And so everybody kind of goes down across over this survey and you're looking at it because it's a pretty picture and you're like, oh, okay, I kind of want to put a fence here, the client says. I want to bring it up here. Here's the warning. As a broker,
keep your mouth closed. Don't give them advice on where the fence should be or how many feet over from the side of the house is the property line. All of that will be called interpreting the survey. Guess who gets to interpret a survey? Not us. A surveyor. Maybe an attorney. Definitely not a broker. So don't give them advice on the survey. Here's another example of a survey. A nice pretty one. Got a seal. Stamp on it. It actually has some setback lines. If I can zoom in. Oh, good. There we go. It gets it a little blurry, but you can kind of see it's talking about overhead electric up here. That's involving a power line, and it's showing just how close to the property line the driveway is down here. And it's 12.4 feet at this point, and 5.1 feet over here. So this dotted area is talking about sort of an easement. And then setback lines might appear in some surveys as well. What's the deed look like? It's the title. It's like the title of your car. It's the document that proves you own it. And it conveys your right of ownership. You have your deed for your property. When you get a buyer for your property, a new deed will be created because it needs to reflect the terms and the parties affiliated with that purchase. So it's not the same deed that goes from one to the next. The deed is good for you because you bought it from that specific seller. When you get ready to sell your property, the closing attorney, the settlement attorney is going to create the new deed. And then at closing, you, the seller, are the only one who signs that deed. You're conveying it to the buyer. The buyer doesn't sign the deed. We're going to learn that in a little bit. I'm giving you a sneak peek. So a testable question on the PSI, which party signs the deed? Don't say both. It's not buyer and seller. It's only seller. It's only the grantor who signs the deed, not the grantee. So a deed is just evidence that you own it, evidence of title to real estate. It represents that bundle of legal rights we learned about last week. It also helps you with recovery or retaining your ownership or possession. It has your name on it. Even though the buyer doesn't sign the deed, the buyer's name is on the deed, just not their signature, right? So their name is on there. It goes from, the deed will say, this party as seller is selling the property to this party as the buyer, or something along those lines. When we talk about contract law, sometimes we're talking about North Carolina laws. Sometimes we're talking about just basic general common law. Under common law, just common law principles, title transfers from one party to another when that title or that deed has been delivered to the new party and they have accepted it. It's not good enough for you just to deliver it to them. They have to say, I accept this. I will take it. You can't just throw it at them and they never find it. They have to consciously, voluntarily accept it. So it's delivery and acceptance under common law. But in North Carolina, that acceptance is considered having taken place once the deed is recorded at the Register of Deeds office. So recording is crucial in North Carolina. That's what we are looking for a closing. In fact, I don't count my commission dollars earned until the deed is recorded and the paralegal has called me or emailed me and said, hey, we are on record. The deed has been recorded. That's when I start celebrating. I don't HGTV it. I don't celebrate to that level when it's a listing, because a million things could happen between that point of getting the listing and the closing to keep it from closing. It's only when it closes, and even past the closing is different from the settlement, by the way. You'll see when we get to contracts, a date called the settlement date and another date called the closing date. We hope they're the same date. But settlement is when you get together and sign the paperwork with the closing attorney or the settlement attorney. Closing happens when this happens.
the deed being recorded, that's the closing date. Sometimes you get everything all signed, but it just so happens it's Friday at 4 p.m. What's significant about 4 p.m. on Friday? The Register of Deeds office is closed. Even if it's an online thing, you can record a deed online, but it still requires a person to be there to do the recording. And if it's 4 o'clock, you're not recording that deed until Monday. Wait, but the buyer has all their stuff on a truck. Can we just go ahead and give them the keys? It's up to the seller. If they want to give the buyer the keys before they themselves get the money from the transaction, they may not. They don't have to. Because what if that buyer throws a bonfire to celebrate the new house and they burn the place down? They're not the new owner yet. Also, you need to get some insurance coverage. Make sure the seller keeps their insurance in place through the weekend, because we're not closing till Monday. We had a settlement today on Friday, but we're not closing till Monday because it's not until Monday that the deed can be recorded because the office closed by the time we got everything signed. Very real world problem that happens all the time. A delayed closing. We're going to talk more about chapter 4. Let's see. Yeah, we got a few more slides here, and we're just continuing on in order. I think we do hit 20. Let's see here. Yeah, we're going to do 4 and units 4 and 5 and 6, and then we'll hit environmentalists real quick. That's a short chapter 20, unit 20. But once we get past 20, what comes next? The all beef patties in this Big Mac that is called pre-licensing. 7, 8, 9, 10, 14, 15, 21, and 17 are big chapters. So buckle up. And with that said, I will see you next Wednesday. Let me know if I can do anything to help in the meantime. And I'll see you then. Oh, put your name in the chat. Thank you.
Thank you.
You're welcome.
Hey, I just want to make sure I had your email correct. I emailed you, and I don't know if you're just busy or if I just had the wrong email written down.
Was it this one in the chat?
Let me double check. I'm pretty sure that's correct. Hold on.
Let's see here.
Yeah.
Okay, let me see where that might have gone. Is that from the 3rd?
Yes.
Is that more recent? Okay. Okay, sorry about that. Let me
No, it's all good.
make sure I get that pointed in the right way. Let's see here. Gotcha. Hang on just a second if you can, Rebecca. Did you have something, Kathy? Can I help you? We okay, Kathy? Okay. It's just us. I think. 1 second.
No, you're good.
Okay, now it's just us. Yeah, so you live in Raleigh now, you're moving to Charlotte in June. The brokerages that I know tend to hire provisional brokers include a lot of the bigger named ones, like Keller Williams, EXP maybe. The thing about EXP is there's a little less, like their brokers in charge, all of it is sort of virtual, so it may not be the best place for a brand new agent to start, but you know, if you find an EXP agent, yeah, you might personally want a little more than they have to offer you. Hang on a second too. Get rid of that live stream.